for urgent motion in your lordship.
Give the slip, give the slip.
My lord, they are permitted to mention.
Give the slip, sir.
Very great.
Avinash Kankan is appearing.
My lord, may I take 1 minute, my lord? May I mention one matter, my lord? I had given the slip 3 days earlier also. My lord, the importance and the importance of the matter is this: a public office is being held by a person who stands disqualified under Section 33 of the West Bengal Election Act, my lord. He has been dismissed from the central government service for misappropriating 1.15 crores, and the State Election Commissioner has passed an order that this is not an act of corruption. There are judgments to this effect, my lord, that this is an act of corruption. Leave had been granted to me by previous, my lord, benches also to mention the matter after the pleadings are complete. Pleadings are complete, my lord. Subject to your lordship's convenience, my lord, if it can be taken. I will take 5 to 7 minutes, my lord. I'll just cite 2 judgments, my lord, on this point. Well,
The hearing matter. We'll
it's
see.
a hearing matter, my lord.
We'll see.
Grateful.
Lordship, may I be permitted to mention one matter, Lordship?
Yes.
My Lordship, we intend to file a writ application on behalf of one of the petitioner who happens to be a member of the Bharatiya Janata Party, and the petitioner intend to conduct a Tiranga Yatra on 26th of June, Lordship, in Dinahata. So to that effect, we have made representation to the SDO as well as to the officer in charge of the Dinahata police station. But till date, no permission has been obtained, Lordship. So we are intending to file a writ application to that effect, Lordship. Can it be fixed on Monday with the direction of?
Have you already filed it?
Lord, my junior is there, Lordship. I am praying for leave, Lordship.
Why do you need a leave to file a writ?
Lordship, because we intend to move the matter on Monday, Lordship, because it will be the last week of the circuit, Lordship. That is the main
But
issue.
why Monday? You file it, it will come on Tuesday, Wednesday. You file it.
Lordship, only difficulty is, Lordship.
First you file it, then you mention it.
Will come personally on Monday.
Already one matter is fixed before your
So you file it and then you mention it.
Okay, Lordship.
So, Lordship, may I be permitted to mention 2 matters, Your Lordship? One is hearing matter.
Give the list.
Yes, allowed to mention a matter. It is a hearing matter. Petitioner is in custody till 9 months. For about 9 months, it is the writ petition was heard on 9th April 2025.
Give the slip. Give this. Call out the list.
Item number 1.
This was originally preferred against the bank, seeking a direction for completion of the process of OTS. Subsequently, when the matter was taken up, we were informed that the OTS has been cancelled. Subsequently, thereafter, we received the communication of cancellation. Now, in view thereof, this has now become infractious, we will kindly grant us the liberty to file it afresh, incorporating the fact of cancellation. That's my only response.
Lordship, actually, there has already been a decree from the Learned Debt Recovery Tribunal, and a recovery proceeding is going on. The petitioner is just lingering the recovery of the public money and filing writ petitions on one pretext or the other. Lordship, this writ petition was filed on the ground that certain documents have misplaced from the custody of the bank, whereas it was misplaced from the records of the Learned Debt Recovery Tribunal, and those orders have already been filed with affidavit, Lordship. And now, Lordship, they are actually praying for leave to file afresh. This is just lingering the recovery of the public money.
I'm not giving them any leave. Whatever right they have in accordance with law, they will do.
Lordship.
Learned counsel for the petitioner seeks to withdraw the present writ petition with liberty to file appropriate proceedings in accordance with law.
Item number 2. This matter is Mr. Konkonda Dilpaji appearing from bench. Due to technical glitches, is unable to.
Yesterday also the same story. Today also the same story. You start. Same stories can't go on, sir.
We'll see that matter where specific provision for appeal is available, Madam.
This can't go on.
And moreover, it is.
I'll pass it over. You ask him to join whichever way he wants to join. All right, otherwise withdraw this and file an appeal.
Lordship, then.
Pass over.
On 2 PM, Lordship.
Not 2 PM, pass over.
I can all plead.
Yes, sir.
This is a matter related to the recruitment of the Anganwadi for Calcutta. My lord, they have, my lord, filed several applications in order to know that whether they, what is the cutoff marks and what marks they obtained, and whether there is any vacancy. They said that there is no data. Now, my lord, in the earlier occasion, the larger advocate appealed for the state. And he filed a order of the court saying that the process is, my lord, is my lord, this is the order, your lordship had it over with the copy. My lord, from the order, my lord, I got from lordship can you see? The order says that W23113, the second last line, 2023-22, in this matter, the entire process is stayed.
Yes.
So lordship, thereafter, you lordships can ask me to check all the orders, but I have checked. What I have found is this restitution has already been dismissed, lordship, so there is no stay. My lord, admit, according to the advocate, so the state is saying that there is a stay. If there is a stay in respect of this recruitment process, then lordships, they are, on the other hand, they are saying they do not have any data record with regard to the recruitment process. How can it be possible, lordship? I'm asking this question to myself. My specific instruction is this: there is no stay. They are proceeding. They have taken, my lord. They have given appointment, my lord, very recently from the state, my lord, recruitment process. So
Where's the state?
No stay.
Where's the state? You're appearing? At a very belated stage, madam, you are asking for documents. I'm not going to allow that.
But my lord, kindly see, the process is, my lord, in force, not that the process has been over, my lord, long back.
There is no process in force. The order doesn't show that there's any force.
The order says that the stay
Stay is vacated. There is nothing there. Nothing there. You are appearing? You are appearing?
Yes, Lordship.
Yes. The stay has already, stay doesn't really make any difference to the facts of the present case. It doesn't help her. Yes, madam. No, this is too late.
The cutoff marks and high mark, nothing else.
Madam, they don't have the records. That's what they have stated.
The one hand, they are saying that there is stay. And the another hand, they are saying they do not have the record.
That was a wrong submission made by him.
Lordship, kindly consider, because my lord, what is my lord on, it's going on, lordship. So
The
my lord,
petitioner has filed the present.
my lord, report, lordship.
Oh, madam, there's nothing here. The
Lordship.
petitioner has filed the presented petition seeking cancellation of the recruitment process initiated for the post of Anganwadi Sahayaka under the Mekhliganj ICDS project, Cooch Behar, as advertised wide notification number 164/ICDS/MKG dated 16/11/2009. The case of the petitioner is that all of them had participated in the selection process for the said post pursuant to the aforementioned notification. Full stop. Learned counsel for the petitioner submits that the selection process remained stayed in this court for a considerable period and was eventually concluded pursuant to the order dated 23/9/2021 passed in WPA number 36 of 2021. Full stop. The results were subsequently declared, and none of the petitioners were included in the final panel. Full stop. Consequently, the petitioner submitted an application under RTI seeking disclosure of individual marks and cutoff marks, full stop. The respondent, comma, wide reply dated
7 January 2025.
Ballot page 60, another is page 66.
reply dated 7/1/2005, comma, inform the petitioner that no records pertaining to the said recruitment process were available, full stop. Thereafter, the petitioner submitted a mass representation dated 19/4/2025, reiterating their request for disclosure of individual marks and cutoff marks, full stop. The said representation was also rejected by the respondent while their reply dated 6/5/2025 on the same ground, comma, namely non-availability of relevant data, full stop. It is a grievance of the petitioner that the respondents are deliberately withholding the information. This court has heard the argument advanced by the counsel for the petitioner as well as the respondents and has perused the materials available on record. It is evident from the record that the recruitment process was initiated in 2009 and the results were declared in the year 2021. The petitioner sought information only in the year 2024 and 2025. Full stop. The respondent declined to furnish the said information on the ground that no records pertaining to the said recruitment process were available. It is apparent that the petitioner had approached the respondents with substantial delay, full stop. Therefore, comma, the respondent cannot be faulted for non-availability or destruction of the record after such a prolonged delay, full stop. After such a prolonged period, full stop. Mere non-availability of records cannot, comma, by itself, comma, lead to a presumption that the selection process was tainted or vitiated in any manner, full stop. In light of the above, comma, this court finds no justiciable ground to interfere with the selection process, full stop. Accordingly, comma, the writ petition stands dismissed. Saurabh, ground to interfere कर देना, no ground to interfere. उसके बाद वो हटा दो with the selection burden, no ground to interfere. Next.
Sorry, but.
Yes, Mr.
Very good, yeah, man.
Yes.
Can I apologize?
Yes.
Hello. I am for the petition.
Yes.
Here I have challenged the order of the Commissioner of Civil Municipal Corporation,
Yes.
by which order he asked for demolition of portion of building.
Yes.
They already said it is beyond the sanction of the building plan.
Yes.
Order is at 71, my lord.
Page 71.
Chapter 71. The operative part order is at
Yes.
70. No. I just, no, because I just specified. She knows that in West Bengal, the initial design is called Bengal Municipal 1932.
Yes.
Siliguri Corporation was constituted in 1990 because Siliguri Municipality. It is 32 Act. And my first building plan was sanctioned in
81.
no,
That-
62.
62.
This is date I know.
Yes.
This is my lord. At page 39, my clerk may give the backside. Page 39, the building plan was sanctioned. And page 62.
Yes.
And it is under the Bengal West Bengal Municipal Act 1932, admittedly because under the rules, this act, there is no rules. The schedule of the act says how building permit will be given. 62 mile. Then my lord, next can comes my lord. At page 40, again a building plan, this revised plan of building plan was given 1963 or renewal plan at page 40 mile. At page 63. In the 1963.
Yes.
Then my lord, a building plan was given in 1972. This is for go down in the same premises
Page?
at page 41.
Yes.
My lord, lastly, the plan, it may be the other plan which are available to us. That is at 1981, a building plan was given at page, my lord, 42. And my specific apartment that the lordship can see the Monturam overall, who was the predecessor of both the petitioners and the private respondents.
Yes.
My lord, he got the plan. He was the owner of the building. There might have some revised plan also did not have. These are factual and coming to point of law. My lord, Monturam died in 2014 at page 43.
Yes.
Then both the petitioners and the private they're sitting in the same building.
Yes.
The private respondents file a suit for partition, page 44,
Yes.
and there is order of status.
Yes.
But this is the factual aspects.
Yes.
Then what happened, my lord? A order was passed by this Honorable High Court at page 52 on the basis of the representation of the private respondents regarding illegal construction. You can see at page 52. The Honorable High Court was pleased to consider this representation. It is my instructor that was not served, might be served, but the order was passed. The
Yes.
copy of the representation was not supplied to me. This is at page 52. This is the December 20, 2024, the representation was made. But this is the factual aspects, what was passed. Now I will can come through. Now the present demolition was started at page 55. At page 55.
Yes.
Now you also can see that they have said that 9 January to 25 an inspection was made. It was
Yes.
But in the notice, the relevant part of the report was quoted. So you can come. There's 56.
Yes.
Inspection. One partly two-story, partly two-story building. Based on building with some semi-park structure and found on the plot in the ocean. North side dimension of building is such and such. So, mechanism. Area of address portion is 13,104 square feet. Address portion is located at the central portion of the building. It is not said it is beyond the sanctioned building, nothing was said. Yes, because it was pointed by my arrangements, every respondent. This address portion is located the central portion. Next says, address portion was during inquiry is found that interior work is being carried out at the first floor without obtaining permission. So the report says, address portion whether this violation of plan or not, that is not said. They said that the interior work was going on without this is the violation as per this report. Then my lord, the second come to again. The hearing was given many times. My lord, then my lord, again a report was made. Sorry, my lord. Given a notice. Yes. My lord. Again, notice was given. At place 57.
Yes.
Now, because now the inquiry was held, my lord, on, they say on, my lord,
Yes.
this is, dated, given here, 9, but this report is, 9 January 2025.
It's the same report.
Yes, again, he notice was given.
Yes.
Now, my lord, can you see, now can you page 62. Hearing was held by the both considered there. Notice was given for a joint inspection. At page
Yes.
62.
Yes.
Again. So on the basis thereof, an inspection was held, but I made a to the commissioner that the private respondent did not allow to make the report properly. That is my regular petition. Now, my lord, can we come to stated at page 71. The input order. Well, so the first, second paragraph,
Yes.
the first report was quoted, what I placed before us, 9 September 2024. So can you see, same thing at page 72, that was quoted.
Yes.
But say there's no violation set into your word. Now you're standing relevant position, the standing order, and come to page 74.
So there are two inspections which are done. One is on 9/1/2025
Yes.
and 7/5.
Yes, 7.5, you are not supplied to us.
Yes.
Now I'm at page 74. Second report. Here's the record heading.
Yes.
As a copy of the billing plan submitted by the complainant, the date and particulars of billing was not given. Previous hearing was not easily decipherable. A fresh copy of the plan was submitted by the complainant with a subsequent hearing. Upon presentation of a fresh copy of the billing plan, the concerned submission was submitted. A revised report, the quantity report submitted by the complainant are as follows. There are no construction activity found during inquiry. First, during hearing of the petition submitted fresh photograph of sanction building plan, pen type containing the soft copy of building plan, after thoroughly scrutinizing the measurement as per sanction plan and part 50 of building, it is found areas portion shown by the petitioner lies beyond the sanction building plan. Now, second report says this beyond the sanction building plan. And this is next minor. Now I'm on this, my lord. My first submission is that, my lord, that it is not specified when the building plan was sanctioned, under which building plan was violated. Not say. But there are 3 and 4 building plans, my lord. I have shown number 61, 62, 63, 81, there may be other revised plans also. They could not produce the original building plan. They said, my lord, this is the secondly, my lord, report was not supplied to me. The third one I said, please, your lordship, that they should say which portion was unauthorized as per the building plan, particular building plan. Those are not given. And next I place one point. And this is one of law. And you can see the act itself. Section 287, madam. Here the commissioner exercised the power of section 287. Can he come? Subject to the commissioner's statement, if the commissioner is satisfied that the erection of building has been commenced without obtaining sanction or under these acts. So she can, they have to first point out whether this construction was done in violation of this act or not, 2006 act or not. This building was planned under Bengal Municipal Act. She can exercise the power, and my solution is that.
Mr. Rai, there's a direction passed by the coordinate bench of this
To see.
to see and obviously to take action in.
As per the representation, there's no special order of demolition. To consider representation, I can see, don't go beyond the representation. This is order.
So you mean to say that since the first sanction plan
Yes,
is of the year 1963 or 62,
yes.
today the commissioner has no power. You can
No,
go,
it's a legal fiction.
you can go.
My first point is that, madam, they should set the particular sanction with it, which was violated. But this time was not done. It's a robbing and good. Commissioner is satisfied, he should satisfy. He must form an opinion. He must form an opinion. He is relied upon a report of the second report. The report was not given to me. First report was not given to me. Second, my lord, How is the report, that was said, it is not.
You participate in the inspection, Mr.
Supply, that was supply. The sanction building plan, that which was the sanction building plan, particular building sanction plan was not given. Because there are 4 buildings, there may be some revised building plan also, my lord. Thirdly, my lord, was to see that if the report I got, then I can report that to send you for the particulars building plan. Next, my lord, what I said before lordship, that regarding, we are saying the same building, same private respondents, and see the state that I say that power, my lord. This is a point of law. My lord. Now, next point is my lord, and come page 74. Fourth paragraph. But this act is very, very gross. They-
Yeah.
And my point is that
Page 74.
74, I see. But fourth, hence the division as noted above and beyond the purview of the conditions as laid down by the notification of the government of West Bengal. But there is no, you also knows it. The new notification has come that regarding if the minor deviation, minor, as per the 5% mark, I see the rule is also in the rules also. Designate to. The rule 32, second provides. Just
Just a minute.
Municipal corporation is municipality municipal corporation.
So the related parts.
Yes.
But I say rules.
Yes.
Rule. Second provides.
Rule 32, second rule.
Provided further that Board of Councillors may by order regularize a minor or other population or execute any minor work because sanction under these rules or minor deviation from the sanction.
Rule 37.
No, sorry.
Which rule?
Rule 32.
32. 32 is demolition of unauthorized construction.
Yes, this is the second. New provisos come, second provisos. As the second proviso. These are rules, second regarding the procedure for demolition. There's no, there's. Second provision for newly worded, provided further the Board of Council may by order regularize a minor unauthorized configuration or execution any minor work without sanction. Under this rule, a minor deviation from the sanction plan or executing any minor erection or work in confirmation of sanction plan under this rule. This is my rules, this incorporated, this is incorporated. 2000 23. On the basis of that, my lord, they have given a one, my lord, notification. And come to page 76.
Page 76.
This notification was given by the state government and come to para 1 small b. Change of sanction covered area of the building of with variation up to 5%. But my humble submission is that the total covered area of sanction building as per 62 Act, 62 sanction, whether this LS construct of 13 square feet is falling in the 5% norm, that is not taken into consideration. Last one is he relied upon the report of the inspector, engineer at first. His division has not have beyond the power of this laid down. They should stay. This is a sanctuary building plan. This is the area. So it may come under 5%, may not come 5%. But this is only a non absolutely order based on subjective satisfaction. You also appreciate. This is a commission. He should pass an order being satisfied with no any illegality. He is just simply write up the report. Report does not say anywhere, but it comes with 5%. But the reason object is frustrated. So, first one, I just sum up my first is there's a building plan of 1962, 63, 72, and 81. It may be that the subsequent plans that was not with us. Secondly, my lord, this is a dispute between the family members. We are staying in the same building. Third, my lord, that first instance report does not say that LS portion is beyond the sanction building plan. Revised report says that there is some beyond the sanction building plan, but particulars of the sanction building was not given. The area which was in deviation that was not given. Nothing was particulars given. Fourth, my lord, I have taken the point when your lordship said, but the court has asked, commissioner, yes, correctly. But what I'm saying, what should be extended under this act? Then she has to take into note of the board of council is also there. Under the rules, board of council can do it. In the corporation, the board of councillor, that's the highest body. Under the rules, board of councillor can do it. So if the act, what I like to submit, my lord, under this act, the power of the commissioner is limited that he should take steps as per this rules act. Any violation. But board of council is there under the rules. They can do anything because it's a collective force. Second, my lord, this if I should regularize or not, even it will fall the 5% or not, that has been taken into consideration. This is my opinion.
None. Yes.
My lord, I am appearing on behalf of the corporation.
Should I for the private respondents, let the municipality votes.
My lord, 4 points have been raised by my learned senior. Number 1 is the building plan. My lord, kindly come to page number 6 of the read petition, my lord. In 4A, paragraph number 4A, the initial building plan was passed in the year 1962 for construction of the building, which my learned senior has pointed out that it's in annexure P3. In 4B, second building plan was passed, which is again for construction of the building, which is annexure P4. 4C states that building plan has been passed for construction of godown, that is P5.
Yes.
4D is regarding construction of the portion of the existing ground floor, that is on the existing ground floor and proposed portion of the authorities, that is annexure P6. So 4 building plans can be found from the writ petition, out of which 2 only are for the construction of the building and the residuary 2 are for the construction of godown and extension of the portion of the ground floor.
Yes.
My lord, second point which was taken up by my learned senior was this is a dispute between family members. A civil suit has been filed. There has been an interim order to the extent that the status of the building that the status of the building should not be changed. A writ application is filed by the complaint by Suresh Garg, Sumit Garg, I stand corrected, and that is being WBA number 40 of 2025.
That's right.
In that application, the learned court has bound our hands that we cannot go beyond the representation which has been submitted by Sumit Garg. So, on the basis of that solemn order, my lord, investigations were made.
Yes.
First investigation was made, and in page number 55 to 56, the notice which was issued, my lord, your lordship will find 55, 56. Yes, 55 and the operative portion is 56. Your lordship will find that the operative portion of the inspection report
Yes.
has been quoted in bold letters.
Yes.
So what my learned friend stated that he was not aware of the inspection report, that is absolutely not correct. It was supplied.
Yes.
It was stated to you. You were aware of the facts. Be as it may be. I'm so sorry, sir.
We'll come back.
Yes.
Yes. Yes.
My lord, in page number 57, your lordship will find that the second notice has been issued on 3rd of March 2025.
Yes.
In the said letter, running page 2, page number 58, again your lordship will find that the inspection, what has been found from the inspection, that has been stated and quoted.
Yes.
So, the petitioner in this writ application was well aware of the facts that in the inspection, these anomalies were found, this over construction or unauthorized construction beyond the building plan has been found.
Yeah.
No, it's not saying there. You see.
Just a minute, Mr. Right. Yes. Yes.
My lord, the fourth point which has been taken by my learned senior was that there has been a notification dated 4th December 2023. This notification is regarding regularization of the unauthorized construction.
Yes.
But the commissioner does not have any authority.
Yes.
The application has to be made before the Board of Councillors. The Board of Councillors, my lord, here it is stated, will be determined by the Board of Councillors whether there are minor deviations or major deviations. And if it is found that they are minor deviations, then they will be regularized. That is upon the Board of Councillors. So here the commissioner does not have any role to play.
Yes.
Fourthly, my lord, my humble submission is that, my lord, this is a judicial review of an administrative order which has been passed.
Yeah.
My lord, here, my lord, the scope of interference to the order is very limited to the extent that whether there has been any infirmity in the decision-making process which has been undertaken by the commissioner, whether opportunity of hearing was provided, proper opportunity of hearing was provided or not, that has to be gone through, my lord. And that's all which I would like to say.
Yes.
Everybody's private is here.
Lord, I'm for the private respondents.
Yes.
It was on my complaint that the proceeding was initiated.
You have a nice nephew.
Yes. Basically same house.
Now, my lord,
Yes.
I'll take your lordship again to page 76, which is the notification that my learned senior is stressing upon. Now, my lord, he is stressing upon 1B. The UDMA notification 1B. It says change of sanctioned covered area of the building with variation up to 5% without addition of any new component. This is, my lord, very important. This 5% restricts itself to any deviation without addition of any new component. Here in the present case, a two-storied building has come. The original building, my lord, is bordering the circumference of this entire area. There is a vacant space in the middle portion on which they have come up with a two-storied building. Now, my lord, these are some photographs with timestamps. Very recent photographs, my lord. if by any stretch of imagination, this construction looks like it is only 5% of the previous building, then my lord, I have nothing more to say. I have nothing more to say. So they have not only added a new component, which is a two-storied building adjacent to the existing building, they have also deviated more than 5%, which is apparent from this, my lord, photograph.
Yes.
Now, my lord, lastly, my lord, my Learned Council of the Municipal Corporation has stated that this honorable court's order had tied their hands. And my lord, there is sufficient relief liberty which has been given in my lord the order itself of the SMC. Takes up my lord the order once. Page 75 is the relevant page, my lord. Last two paragraphs. It says, therefore, this order has been confined solely to the alleged portion of the building in question as per the scope of the representation submitted by the petitioner dated 2012-2024. However, the opposite parties are at liberty to submit their representation with respect to the remaining part of the building in question before the undersigned, and necessary action shall be taken accordingly in accordance with the provisions laid down under the West Bengal Municipal Corporation Act 2006. Now, my lord, the petitioners are trying tooth and nail to stop the demolition of this illegal portion, and as a result, my lord, what they are doing is they are pointing towards internal deviations that may be found within the existing building. So that was their first line of attack. When they did not succeed in that, now they are trying to, my lord, make a case before this court that it falls within the 5%. But that 5% has to be read with the words that precede it, which is without addition of any new component. My lord, I'm only relying on one judgment of the Honorable Supreme Court of the year 2025.
Justice Madhavan.
Lord?
Which judgment? Madhavan's Justice
No, my lord.
Madhavan?
Kaniz Ahmed, Justice Pardiwala.
Justice Pardiwala and Madhavan. Justice Madhavan.
Yes. Justice Madhavan and Justice Pardiwala. Para 7, my lord, is very important. 2025 INSC 610. Para 7, my lord, is important. It says, of illegal construction and should not readily engage themselves in judicial regularization of buildings erected without any requisite permissions of the competent authority. The need for maintaining such a firm stance emanates not only from the inviolable duty cast upon the courts to uphold the rule of law, rather such ought not to come to the rescue of those who flout its rigors, as allowing the same might result in flourishing the culture of impunity. Put otherwise, if the law were to protect the ones who endeavor to disregard it, the same would lead to and undermine the deterrent effect of laws.
The other one is more detailed, that Barjatia's Justice Madhavan's judgment is more detailed regarding unauthorized construction.
Yes, ma'am. So, my lord, I'm again stressing upon the fact that the photograph that I have submitted is of the month of March 2024. Now that construction, which was commenced at that point in time, has fructified into a two-storied building, which is the subject matter of the proceeding.
Yes.
Now, my lord, the commissioner has passed a detailed order, as my learned senior had stated, that judicial review of any administrative order which is reasoned enough is not permissible. So what they're trying to is they're trying to relegate this issue once again before this honorable court, which is, my lord, not permissible under Article 226. So, my lord, there is no scope for interference with the commissioner's order, and, my lord, it should be given its, my lord, due result.
The answer, but can I come to page 56? My understanding, the municipality corporation is very clear. First report, they say, this is what first report says, area of areas portion is 12 feet, areas portion is located at the central portion of the existing building. Nothing was said whether it is beyond the sanctioned building plan, whether it is a without sanctioned building plan, whether it is newly constructed. Nothing is said. Says the areas portion of portion. Next, he says some interior work is being done without permission. So the first report, my lawyer said, yes, very clear. This areas portion is areas portion. Whether it is not sanctioned building plan, that was not said. So this is I understand. Now, next report, my lord, can you see in the order itself, case 74, and now to 74, my lord. One moment.
Page 74.
Yes. Second report, what I am asking for, second report, I have case 74 what paragraph.
Yes.
As a copy of the building plan submitted by the complainant during the previous hearing was not visibly discernible, a face copy said was submitted by the complainant during the subsequent hearing. Upon perusal of the face copy of the building plan, the concerned services submitted revised plan. This is here one of the second report. What second report says regarding on 7 May 2025, whether these portions are authorized. Those in other regarding this building plan, there is 4 building plans. Nothing was said. So unless I get the report, first I didn't require because it was given the relevant portion. The second report does the same anywhere. But I'm sorry to repeat again. This should my analysis is a new construction. This is not in the report. This is not in the order. Order does not say it's a new construction. Order does not say it's a construction beyond the building earlier building plan. They said it is beyond the sanctioned building plan. First report does not say. But nothing of particulars are given. By university, might be some illegal person maybe. But that my argument is clear. That should be demolished. But I should get the chance. So they should get the because it's a joint property. It's not my it is their also property. It's joint property. Nephew is also one of the building, is one of the building. He's staying there. So that they should give a particular portion. If they are unauthorized construction, this is without sanction plan, or it is beyond the but they should check 2 things. Either it is unauthorized without sanction building plan, or it is unauthorized construction in deviation of this particular building plan. Nothing was said. Third by my learned friend says, I am very thankful to my learned friend, the 4th paragraph regarding regulation. Then why he has taken the consideration? If the board of councillors power, they say if it is a board of councillors power, then she has exercised it and come to 74. She said no, it's the privacy. Hence, the division has not about beyond the part of the permission as laid down by the notification. The commissioner considered about. He also considered suppose that assuming that he said it's more than 5% of the 5% of the total covered sanction place. It's a 29 decimal building. So I may come, may not count the 5%. But who will decide it? They said it will be decided by the board of councillor. Here, commissioner decided.
Yes.
So you see, pending are the sent back to the board of councillor to see that whether it is 5% or not. I have nothing to see if it's 5% because by the way, this is not my own building, this is also their building. So only your problem. So my lord, if it's a violation, you should give a particular sanction plan. It's a particular our grandfather, his grandfather did it.
But you already have a right. The order itself records.
What my husband said, and just trying to save himself. What they're
You know,
saying.
Mr. Rai, what you are saying, I'm glad you are convinced about it. But the fact remains that this is a completely new construction which you have carried out.
But that was not said. You say, this order not to say.
Or
But you also appreciate, but
I appreciate.
yes, it is an order does not say here. This is not application of mine.
Complete.
And this should be a particular during this is a particular what I'm trying some sorry one. But I'm trying to say they should say this is in deviation of this building plan. But it was given. They should say it's a new construction which is beyond the sanction plan. Nothing was said. Third, they said it should be considered by the board of council. She considered. This is my
All right.
I this report judgment is very it is followed in that here.
I'm also following it.
I know it. I see it. I hear people watching the on behalf of the municipalities.
Yes, that's why I didn't say that, Mr. Rai. I wanted to say it. That you appear for the municipality, you were appearing before me even in the principal bench. And today when you are, alleging impunity in the order and saying, he should have applied his mind, he should have.
No difficulties.
That's why I didn't. That's why I held myself, Mr. Rai. I just held myself, because I was about to say that, Mr. Rai. You know,
We have to appear, but one matter, one criminal appeal, ever taken the capital policy. I would the polite or say, next one you will be. No, just.
all right, take down. The petitioner has preferred the present, the petition. Yes, yes. There's only one petitioners. Okay. The petitioners, huh? The petitioners have preferred the present writ petition assailing the order dated 13/5/2025 passed by the Commissioner, Siliguri Municipal Corporation, whereby the petitioner was directed to remove the unauthorized construction, allegedly made in deviation from the sanctioned building plan, by removal by 31, when is it? By 31/5/2025, failing which the respondent corporation would proceed to demolish the same at the cost of the petitioner. Full stop. Learned senior counsel for the petitioner states that the petitioner and the complainant are co-owners of the premises in question. The construction in the said premises were carried out pursuant to building plan sanctioned on 30th/8/1963. First one is 62, sanctioned in.
Yes.
First, what is the date of the first building plan? Page 6, right?
1962.
Yes.
Annexure P3.
Just a minute. On 22/6/1962, 30th/8/1963, and 18/7/1972, bracket में डाल देना, for construction of godown, and 1910/1981, full stop.
Sanction on 30th of January 91. And
This is what it has
this
been.
81 was re-sanctioned on 13th of January 91. That is what
That's
I-
all right. They have not, it's not mentioned. It's not mentioned.
It's annexure P6. P6 is the plan of 91. But you will find.
They have not mentioned it. Renewed in,
Six.
and the same was renewed on 21st, on 22/1/1991. Full stop. All right. It is further submitted that there exists an inter se dispute among the co-owners concerning the title of the property, and a civil suit in this regard is currently pending. Full stop. Learned counsel for the petitioner further states that he was not given the copy of the inspection report. Full stop. Yes. He further contends that the commissioner is not authorized to pass the impugn order since the sanction plan was of the year 1962. Full stop. He further states that the notification dated 4th December 2023 has not been considered at the time of passing of the impugn order. These are the submissions. That's it. All right. Learned counsel for the respondent, municipality, corporation or municipality? Siliguri municipality. Siliguri Corporation. Yes. I said that, no? That's the 4th December 2020. SMC. Learned counsel for the respondent contends that the first building plan was sanctioned in the year 1962 and subsequently another plan was sanctioned in the year 62 and another was sanctioned in 1963. And the building plan of 1972 was only in respect to construction of the godown, full stop. He further contends that the extension portion of the existing ground floor and the proposed portion was sanctioned in the year 81 under the provisions of West Bengal Municipal Act 1932. He contends that the petitioner has carried out the unauthorized construction beyond the sanction plan of 81 as well as the renewed sanction plan of 22/1/1991. That's the contention. One, what else?
Secondly, there is a dispute between the family members and civil suits have been filed.
Learned counsel for the respondent further contends that the interstate dispute between the civil dispute between the parties have no relevance to the present proceeding since the present proceedings were initiated on the complaint filed by the private respondent dated just a minute.
December 20, 2024.
Civil dispute between the parties has no relevance to the present proceedings since the present proceedings were initiated on the complaint filed by the private respondent.
Private respondent in the year
December 20, 2020.
private party 20th December 2024. It is further contended by the learned counsel for the respondent that the private respondent had filed WPA number 40 of 2025, wherein an order was passed on 20th of January 2025, where direction were given that the municipality shall hand over the copy of the inspection report upon the petitioner and the municipal commissioner, after granting an opportunity of hearing, shall decide the representation of the private respondent dated 20th December 2024 by passing a reasoned order within a period of passing a reasoned order. Full stop. Yes.
And not to travel beyond the scope of the said representation dated December 22.
And pass a reasoned order and
First paragraph, last two lines.
which paragraph?
First paragraph, page number 3, internal page number 3.
Yes.
First paragraph, last two lines. The jurisdictional municipal commissioner, but the
alright.
same shall not
Yes.
travel
Kalika.
Granting opportunity of hearing shall say the presentation of the private respondent dated 20th December 2024
And shall not travel beyond the scope of the said representation. Full stop. What else?
regarding the regularization.
Yes.
If they make application before the board of
Learned
councillors, that will be
counsel for the
considered.
respondent further states that the impugn order itself states that it is only confined to the representation of the petitioner and that any representation made by the petitioner for what is it for regularization of the deviation in accordance with the West Bengal, Government of West Bengal notification dated 4th December 2023 is open to the petitioner. Full stop. Private respondent. This private respondent, counsel for the private respondent, number so and so, states that the petitioner has carried out the unauthorized construction in gross violation of the sanction plan. He has stated that the entire construction is afresh and has nothing to do with the earlier sanctioned building plan. Full stop. This court has carefully considered the submission made by the learned counsel for the parties and has perused the pleadings as well as the documents placed on record. The core issue for consideration in the present writ petition is whether the impugned order dated 13/5/2025 directing removal / demolition of a portion of the construction measuring 1,304.38 square meters alleged square feet alleged to be in excess of the sanctioned plan, comma, suffers from any illegality, comma, procedural infirmity, comma, or violation of natural justice. Full stop. The record reflects that, comma, in compliance of the earlier direction of this court in WPA number 40 of 2025, a joint inspection was carried out by the officials of the respondent corporation. Full stop. During this inspection, specific deviation from the sanctioned building plan dated 19/8/1981 were identified, comma, particularly the unauthorized construction measuring 1,304.38 square feet. Full stop. The commissioner
One three zero 1,304.38 square feet.
1,304.38 square feet. A page 56. The commissioner thereafter issued a show cause notice and afforded the opportunity of hearings, comma, thereby complying with the principles of natural justice as enshrined under Article 14 of the Constitution of India. Full stop. It is well settled that construction made in deviation of sanction plans are per se unauthorized and cannot be permitted to subsist. Full stop. The petitioner, comma, while claiming the deviation to be minor, has failed to place on record any specific provision or notification or relevant building rules that permit regularization of a deviation to the magnitude of 1,304.38 square feet, comma, particularly 1,304.38 square feet, comma, particularly after a lapse of several decades. Full stop. Even otherwise, comma, the mere passage of time does not render any unauthorized construction legal, nor does it create any equity in favor of the wrongdoer. Full stop. Further, the contention of the petitioner that no inspection report was furnished does not vitiate the entire proceedings in the present case. It is not in dispute that the inspection was carried out in the presence of the petitioner as recorded in the orders of the municipal commissioner. Full stop. There is no document placed on record whereby the petitioner is disputing the joint inspection report conducted in pursuance of the hearing held by the municipal commissioner. Full stop. The impugn order itself discloses the basis of the commissioner's decision, comma, namely, comma, the findings from the joint inspection and the extent of deviation, full stop. The petitioner was duly heard in the matter, comma, and the materials relied upon by the authority was disclosed in substance, comma, fulfilling the requirement of fairness and transparency under administrative law, full stop. This court, comma, therefore, comma, finds no procedural impropriety or violation petitioner's rights that would warrant judicial interference, full stop. The order dated 13/5/2025 appears to have been passed after due application of mind, comma, following statutory procedure, comma, and upon objective assessment of factual findings, full stop. The court cannot sit in an appellate authority over factual determinations made by a municipal body acting within the confines of its statutory powers, comma, unless manifest arbitrariness and or malafide is shown, which is not the case in the present matter, full stop. In view of the above, this court does not find any merit in the present writ petition. Accordingly, the writ petition is dismissed.
Yeah.
Your Lordship, in item number 5,
Yes, Mr. Banek.
in item number 5, just today morning,
Yes,
the CGST department
yes.
informed me that this case has been filed, but no copy of writ petition has been received.
Who's there in item 5?
Next week. Lordship.
Nobody is here, Mr. Banek, for the petitioner also.
Yes, yes. I'll fix it next week.
Not today, Thursday. We'll have it on Thursday.
Grateful. Yes, yes, yes.
You are appearing for Mr. Dhar.
For the petitioner, Lordship.
So give a copy to Mr. Banek. Why you have not
I'll
given a
give him
copy,
a-
Mr. Dhar?
Lordship, he may supply me the his
You know,
email
if-
address in my chat box.
Yes,
File
yes,
box.
yes.
I'll-
Yes, I'll provide.
Yes, give a copy.
Lordship.
Grateful.
Next Thursday, Lordship.
And this is connected actually, Mr. Dhar.
Yes, this is connected with another writ petition which is pending before this honorable court on the allegation that parallel proceedings has been initiated. And in that matter, they are asked to submit a report.
So, Mr. Banik, we can list it with that writ petition. There's a writ
in-
petition. What has happened is there was 2 notices which were issued earlier. They had filed a writ petition,
Yes, yes.
370. And
Ah.
again, you have issued 2 notices to him. So he has challenged this one.
But I do not have the writ petition. of
All right,
that
we'll have it.
earlier-
Give a copy. We'll have it on Thursday.
Yes, yes.
Lordship.
We'll tag it with the other one.
Lordship.
Grateful,
Lordship.
grateful.
You're appearing, Mr. Sarkar? Not.
Six.
6 minute I am appearing for the petitioner.
And on behalf of the respondent, I'm led by additional applicant.
Yes.
That this is against Millard and appellate order.
Yes.
The appeal has been disposed of.
Yes.
Now, Millard, we are challenging both the order of adjudication and the appellate order
Yes.
on 2 grounds. Number
Yes.
1, that the entire demand is on the basis of mismatch and on the data available in Form 26A filed under the IT Act, which is impermissible in law, covered by a judgment of the Madras High Court. The second challenge is, Miller, where I am in a slight difficulty. In the pleadings, Miller, we have said that this entire demand is barred by limitation. Because Miller is aware that so far as 73 and 74 of the GST Act is concerned, the time period has been subsequently extended by notifications issued by the CBIC in exercise of powers under 168A. Now, those extension notifications, firstly, has been set aside by the Guwahati High Court in Bordatuki Mills and very recently, Miller, by the Madras High Court in Tata Play. Miller, I just intend to, Miller, subject to your lordship's approval, Miller, it is pleaded in the writ petition, Miller, one prayer I need to add, Miller, seeking setting aside of those notification on the similar lines, and Miller, one further liberty to add CBIC as a part.
See, if you are asking for a substantial change, then you have to amend the writ petition.
Miller, I am only add one prayer. If Miller grants the leave, Miller, I can.
Prayer can be added only if you make an amendment. Prayer can't be added like that.
In that event, Miller, kindly grant me the liberty to withdraw it and file up. We can do it in.
Learned counsel for the petitioner seeks to withdraw the present writ petition with liberty to file afresh in accordance with law.
Good.
Seven. The copy has not been served upon the private respondent. This has been post in the transition module.
Well, what is there? You are seeking some against the state.
Yes.
Witness. Just see if the IO has been assigned, some IO has been assigned or not. He's basically saying that the IO has not been assigned despite orders being passed. Wednesday, huh? Not today. Wednesday. That's what I said. Monday, I already have too many matters.
Eight. Lord, I am going to petition you.
I on behalf of the state respondent.
Lord, I am on behalf of the private respondent.
Lord, affidavit of service.
Yes, what unauthorized construction?
Milord, this unauthorized construction has been done in the municipal panchayat area, your lordship. I was the owner, record of right is in my favor. I was bought the land in.
Yes, consider the representation.
My lord, I am on behalf of the private respondent. My lord, the entire dispute is civil in nature. My lord,
yes.
finally page number 23 once. My lord, the case is pending before the, my lord, the subdivisional.
Just
my lord, kindly see page 23, my lord.
Yes.
There is a direction upon the block land and land reform officer Mathavanga with a direction to made an inquiry and my lord filed a report. And also, my lord, there is a direction upon the police authority to file the report, my lord. My lord, the matter is sub judice before the executive magistrate.
Yes, you are appearing for the corporation.
No, sir, I am appearing for on behalf of the state respondent lordship. Only
The state is here. Who's
Mathavanga lordship.
you appear for Mathavanga.
Mathavanga.
This is a panchayat sanction.
No.
Who's the
Your lordship.
who's the answering respondent?
Pradhan, your lordship. Pradhan of Hazard.
Have you served him?
Yes, your lordship.
Service is done. Serve him again. We'll have it on Wednesday. And see who's the lawyer who appears for the court.
Good.
Only sent it or served?
Serve your lordship.
Manoj serve hua hai? Somebody appears. I've seen this. Just check out who appears for this Panchayat Pradhan. Come back on Wednesday. Not today. Not today.
Good.
Wednesday, huh? Item 9.
Lordship, I represent state municipality.
Why are you not deciding the representation?
Yeah.
Yes, tell me.
Service has not been completed for private respondents. It is in transit.
Private respondent is
The
not,
matter is pending before the learned DM that can be.
DM is the necessary
Yes.
party, section 14 application.
Yes, Lordship.
Then decide the section 14 application. Why is he sitting over the application for so long? Who's appearing? You're appearing?
I'm being led by Mr. Bode.
Mister? He's there, your senior is there?
No, let it.
Yes, tell me.
Yes, my lord.
Tell me the facts.
My lord, in this matter, first, the petitioner had granted a home loan
Yes,
to the private respondents.
yes.
However, included that, a piece and parcel of land that measuring 2,614 square feet of land was mortgaged to create security interest. However, thereafter, defaults were committed by the private respondents continuously for a period of 90 days. So the petitioners were constrained to issue a notice under section 32 of the Civil Act. The same was published in Bengali newspaper as well. However, even then, after a period of 60 days, the payment was not made by the private respondents. So again, the petitioners are constrained to issue a
No, 14, section 14.
section.
No. Yes.
Possession notice, section 34. Yeah,
34 of?
my lord,
34 of which act?
the VC Act.
Yes, then?
Was also published in Bengali newspaper. There's also placed in a conspicuous part of the property. Even then, the payment was not made, so petitioners preferred an application under section 14 before the learned district magistrate, Darjeeling.
Yes.
This was filed on 9th November 2023, my lord.
Yes.
Even then,
Let them complete the service. You come back on Wednesday. Complete the service. Service has not been done.
Tuesday,
Tuesday?
Tuesday.
Tuesday we'll decide.
Wait.
10.
No, it's 10, but the service on one of the respondent is incomplete.
One of the?
Respondent is income. This is I'm coming after appeal. And Sarkar was assigning this. Are you?
Yes, yes.
Yes, my lord.
Then I can place.
But survey should be complete. Let the service be complete. One of the respondents have not been served. Wednesday? So, Ms. Sarkar, what is happening? No tribunal. So this is after the tribunal.
Yes. No, not after that.
After the appeal,
It is not
the commissioner's appeal,
After the appeal, they have come before your lordship.
because there's no tribunal.
Yes, that's why. That's why.
When do you think you'll have the tribunal?
I have no instruction, madam.
Manas, it will not be very soon.
Then we'll interfere.
Yes.
Madam.
But one thing, Ms. Sarkar, when they file the first appeal, the second appeal before the commissioner, they deposit the amount.
Yes, 10% deposit is mandatory.
Yes, that has to be done.
That has to be.
Otherwise,
Yes,
it's
yes,
not
done.
here.
Next.
Well, item number 11, I'm led by Mr. J.P. Khetan. He'll be coming physically on Monday to address your lordship on this.
Monday we have too many matters.
Manas, kindly accommodate Manas. He does not have really.
Monday we have lot of cases on Monday, right?
Manas, kindly accommodate.
All right. What is the urgency? Why?
Manas, my registration has been cancelled. It's a peculiar case. My senior will satisfy.
Registration
I
has
don't
been-
want to get into the case.
No, but what do you want?
Manas, I'm challenging the registration cancellation of it.
Okay. All right. Keep it for Monday.
I'm deeply grateful. Hello, item number 11, Mr. Amlesh Roy is leading me. He's in court number 1. The short passable may be given.
11 or 12.
12.
12. Well, we'll have it on Wednesday. It's extension of interim order.
No, but they were given instruction, they were given direction.
Mr. Rai is here.
Instructions. Sir, it's a better guess one.
11, 12. Money, what happened, Manu? No, I say what happened, Manu? It's one of the.
Yes, what is the, you have got the instruction?
Yes, ma'am.
You have got the instruction. You're not filing anything in this.
My lord, if your lordship directs us to file an application.
No, let me hear Mr. Rai. What does he have to say?
I say what happened, my lord. It's a old building about 50 years. It's one of the oldest buildings in Siliguri because the building is very hideous building in our Siliguri, Dr. Kalu doctor's houses. So by the side of the Hillgard Road. So my lord, the rule says, rule 160 says, it is given after 50 years, then we can get the rebuilding, can get the rule says. But it is about 46 and 47 years. So we applied for the, this is under section 285, it is for what is I would for repair.
Section 285.
285.
280?
5.
And that say rule, this is rule 163 says, it's a rebuilding after repairs, the 285 and repair. Is it what you want?
Yes.
This is explanation also given there. I will come to the explanation. I mean, what happened, my lord? It is about 46 or 47 years back.
Yes.
We applied for repairing. We are given with the
Page.
can come to pay.
Page 32.
My, 31 my plan, 32 month I applied. As you can see. In regards to above subject letter, I submitted to you. That means above, I request you to provide the approval for conducting renovation, either the memorandum building at Hillgard Road. This regard, I am attaching a copy of the order from the Civil Planning Commission to use our premises and current holding flats without copy of property. Can you let me know if any order, other details are required, and I may best to provide them immediately as the building is currently open for the fourth side. The request to provide us to start work and avoid any aperture. So I assure that I will not be using safety measures. Order, I given this letter. But along with this a structural engineer's report because it's a question of structural safety matter. But you also one page can see at page 36 the report. I place afterwards page 36 of the report is there. So we applied for the repairing.
Page 36 is a drawing.
Yes, this drawing is required. I come. So I made the application for repairing, and then the structure in the report and drawing is given there. I come afterwards. Ultimately, my lord, also can you come to?
But the entire face of the building is being changed to a commercial building. So for this,
Deeply obliged.
Commercial, it's a residence commercial.
no, I follow that.
Yes.
The initial plan which you had,
Yes.
probably that is for a residential building.
No, so but at that point there is no residence commercial.
Correct.
If you
But it
just
was-
come in the new rule, but this is occupation, all commercial.
Oh, that's all right.
The
I-
LIC building is there.
No,
Doctor-
Mr. Rai, the only thing I'm saying is that if you look at the plan on page 36, your own plan, it
No.
looks like you're constructing,
At page 36.
page 36.
This is not, but this is my, I've given this is my law. I've given drawing regarding some change.
Yeah, that's what I'm saying, that
Ah.
it looks like a very substantial change.
No, my lord. Here can you see this is all, there's leave permission I have given, they stop it, I have not given. Only bathroom I have changed. This is bathroom, I just come back, what I have said. Come. So my lord, they give me the permission. This is
Where-
my lord, at page 71. You all later receive right, certain the existing building has been considered in the MIC meeting. Approved, you are therefore right to take this step as per sanction, section 285 or this act has been given the permission. No matter what happened after this permission, there's some, my lord, problem, somebody lost a complaint, I don't know who lost the complaint. One day municipality has come, but only in the existing, you also can visualize, in the existing building, on the old act.
So this is the notice which you have got, right? And then after that,
Notice for violation, but demolition, I'm coming back. Yeah. But so they get the permission,
yes,
my lord, what happened? Erosion considered, there was an existing building on the old act, the road was widened. They, one day municipal has come, at the instance of some complaint.
do you have the old plan here?
It's not with me, my clients is come, that's not the plan. Not the plan. So she can take it Monday, give it back.
বুধবার দিন করুন স্যার হ্যাঁ
Yes, sir. And I bring the plan back. Should one say the juniors to bring the plan. Plan is a very bad condition. I need also to show your last plan also. What I have changed. Because you can take it. What is it?
Wednesday, Monday will be tough,
I'm
Mr.
ready.
Monday I have
on
too many-
Wednesday, my lord.
Wednesday. We have too many matters on Monday.
I will. Yes, maybe.
Wednesday. You file there now. Wednesday. So what is the difficulty, Mr. Lakotia, in what is the difficulty in getting a fresh sanction?
No, there is no difficulty. I can get it. Only what they say, what is, there's no
Because your building you're saying is almost 40 years or
14, 70s.
right? Now when, from what I can see, that the entire face of the building has to be changed if you're going to use it as a commercial property. That's, no, I'm not saying it can't be used. I'm saying it can be used.
Yes, yes.
But my point is,
No, what I'm saying, what they say is very minor. They say you have changed the bathroom, the internal alteration, which is permissible. Second, they say whatever on the boundary wall, that outer wall, that was demolished by them, why, madam? When they give the permission, there's some, problem, someone also complain, the business come say, there's a, it's called cantilever. And your or outer wall is the cantilever. You also know, there is very, the beam hanging in the beam.
cantilever.
Cantilever. That was demolished. So my outer wall was demolished. Now I started to construct by glass. This is only two difficulties. On my glass, why is funds on a new bylaw code is permissible. Rule says that they say it should have, as per national building code says. In all buildings are, you also know that all airports are now glass. Only they ask us, do we accept it? This is only two deviation. I said this is better case. So under
Yeah,
this.
that one, the entire construction is new construction.
I know it was.
I know you know it, Mr. Rai.
Here by a very genuine case, only this is division of the bathroom is here, we have shifted the other portion of the same, There's no increase of the FIR. There's nothing, but this is some problem in the civil town. It's being built up, like complaint. Our outer wall is not there, my lord. We stop. But, my lord, this is two questions, whether bathroom can be shifted without changing of the structural alteration, it is part of the rules. Secondly, of the glass, their main point is the glass. Which is on the new fort is permissible.
What is the difficulty?
My lord, there are a number of alterations, my lord.
No, leave that stop.
Now, slowly but steadily, it will all come out, my lord. There are a number of alterations according
Nature of people.
to the information which I have derived.
Wednesday. We'll sit down.
My lord,
Wednesday.
Wednesday, my lord, should we file a report to that extent, my lord, regarding the information which was sought, but which the learned court
Yes,
detected?
please get the report.
Well,
Get the report.
deeply obliged, my lord.
No, you said, sorry, Michael. And then two, whether bathroom can be without internal alteration is permissible or not. Secondly, whether glass, outer one glass can be.
They'll come up with that.
My lord, I have jotted down while my learned senior was,
Those possible points will be covered.
আমি করে নিয়েছি আমি করে দেবো।
Maori, আপনি বলেছেন,
Yes, Mr. On behalf of the judicial worship.
And Tamal, that Mac appeal. Similar order. Trial court record and.
Hello, Lordship, kindly dismiss the service upon the owner also. He never contested the trial court also.
But you serve him, why do you want, if it's not served, we'll see that, but why at the first date?
No.
Sir? Same orders for both the banks. Same.
14 also said.
Same. Same. And trial court informal payment. Next.
I don't know, 15. Item number 15, madam. I am on behalf of the commissioner.
Yes.
It's a case of transfer of Sawmill license, madam. My lord, the petitioner hearing had given an application to transfer his Sawmill license from Kolkata.
Yes, but now it has almost become infructuous in view of the survey report. What is there?
No, I have given an exception to that report, my lord. They have not passed any order to that score, my lord. My lord, when I have given a transfer application, my lord, they did not pass any order that whether my license can be transferred or not. That is still pending. So I filed this writ petition so that a direction will be given that whether my rightfully or wrongfully, whether it can be transferred or not, a reason order may be passed. They have not passed any order, my lord. Since last 2 years. Now the thing is that
There was
I
a
have,
timber availability survey which was done.
Yes.
my lord, I have done an RTI to that score, my lord. And I have given a supplementary affidavit also, my lord, which clearly says, my lord, that in the year 2023, they themselves have issued fresh license. And fresh license cannot be issued if there is no supply of woods, my lord. In that case, they are giving fresh license. And my lord, in case of a transfer of license, that is not to be considered. And that is what I have given in my
That is
exception.
interdivisional, interdivisional transfer, one division to another division.
Yes.
But the license, whenever is given, is to be considered whether the wood supply is whether in the whole of West Bengal, not only with particular place, my lord. That is what I have given in my exception, my lord. I have also annexed the law to that regard, in that regard. And I am just asking, my lord, a reason order may be passed considering my exception, which I have filed against their report. Nothing more, my lord. If they give an order against me, I'll come before, my lord, I'll go to the proper forum, my lord.
Where is the exception?
Well, I filed.
Copy the
Exception. Yes, it's exception.
Extra copy আছে?
Yes, Mr. Rahman.
That can be done what the petitioner is seeking. If she is seeking a consideration on the basis of the exception that she has filed before this court, both the writ petition as well as the exception may be taken and decided and disposed of by the concerned authority.
Then
Because
we-
apparently what has happened is that the state level committee is yet to take a decision in this regard.
Yes, ma'am.
The SLC has not, in its last meeting, which was held on 21st March 2023, has not taken any, has not made any official direction, has not issued any official direction to the DFO concerned. That is the problem. That is why the DFO is unable to take a stance in this regard. So, my lord, if my lord be pleased, my lord may direct the state level committee as a respondent number 2 in this instant writ petition to take up the matter directly. Respondent number 3, madam.
As per law which I have filed, madam, the exception, it clearly says that the authorized officer is the person who will deal with the transfer application. That is, my lord.
Authorized officer is unable to deal.
Okay, let me submit, ma'am. If your lordship goes to annexure 2, page 17 of my exception, madam, it clearly gives the shifting. What is the procedure of shifting, madam? It says that if the owner desires to shift his sawmill from one place to another, but within the jurisdiction. Now, mine is from one jurisdiction to another.
From one division to another.
See, Ms. Sarkar, the problem is now in terms of the report, you have filed your exception, that's true, but either you challenge the report. If you want, you challenge the report.
My lord, I have challenged the report. I am just saying.
Where have you
passed, my
Where have you challenged the report?
by through means of this exception.
Exception can't be, you have to substantially challenge the report.
Challenging that report only, my lord.
No, that's you have to file a separate writ petition if you're challenging.
Different cause of action.
Is an order, my lord.
See
Then
that
like this.
they can't pass a reason order because that report itself binds their hand from doing anything. That will not allow them to do anything.
My lord, because I have also filed a notification to that court, my lord, the gazetted.
You have to
notification.
challenge if you are aggrieved, you challenge the report. This will not help you.
My lord, what is the function of the state level committee? That also notification I have annexed, my lord.
No, you have annexed.
The state level committee has nothing to do with the transfer application, my lord. I have also given in my report, my lord, nothing to do, my lord, because my license. would have
Today,
given-
rightly, wrongly, the DFO has passed an order.
No order passed, no.
Order in the sense he has filed a report saying that this can't be done because of the survey, the report which is the survey report.
But as
And because of that, it can't be done.
but
So he can't travel beyond the survey report today.
in the year 2023, my lord, they have themselves issued license,
That-
fresh license.
that
which
is-
That is
a new issue. You must treat it in the writ petition.
Miss Sarkar, that is not part of this.
Fine.
That is not part of this.
My lord, I have filed a supplementary affidavit.
Supplementary affidavit will not help me. Either you challenge the report and put all this in a writ petition stating that despite the report which they have filed, they are still in pursuance, in contravention of the report, they are granting licenses. You
Right.
challenge it, it's a separate cause of action. But here, I can't allow them or I can't really do anything beyond the report. You challenge the report,
But cannot,
I can't-
action cannot be given.
can't be given, not here,
DFO cannot do. DFO is.
can't.
Then kindly, my lord, give me a liberty to file a fresh, my lord.
You always have the liberty.
My lord.
Learned counsel.
Cause of action.
Problem, my
It's a new cause of action.
It's a,
lord. Submitted it, it's this.
it's a new cause of action. You always have the liberty.
But they have not passed any order, my
If you want, I can dismiss it
lord, kindly, my lord.
in terms of the survey report. And you can challenge the survey report.
My lord, I've already checked the report in the petition,
All right.
my lord.
I'll give you liberty to challenge it, not by exception. Can't challenge the report by.
In my- how-
You have to challenge substantial writ petition you have to file.
The direction.
Take down the petitioner. Not here. If I had the opportunity, I would have done that. You pursue well, not here. Learned counsel for the petitioner has filed the present writ petition, alleging inaction on part of the respondent, authority in not taking decision on the representation on the petitioner's application dated. What is the date? 10/3/2020.
Fifth of,
Fifth of?
fifth of February 2024. Fifth of
No, your, when is your application?
That's.
10/3/2022.
That is the.
10/3/2022, comma, seeking permission for shifting a sawmill unit from 22D, comma,
Application for shifting is.
it's here, page P3, annexure, page 37, Ms. Sarkar.
Yes, madam. 10/3/2022.
Shifting a sawmill unit from 22D, comma, Motilal Basar Garden Lane, comma, Calcutta, comma, to Moza Chokpuria, comma, jail number 02, comma, Tausi number 91, comma, Parganas,
Patharghata.
Patharghata,
Yes.
comma, PS Bagdogra,
District.
District Daj,
Inter-divisional transfer.
intra-division transfer. Respondent number 5, comma, filed a report stating that, comma, the fifth state level committee meeting on wood-based industry held on 13/6/2022, comma, it was decided to keep the matter of inter-divisional
Divisional
transfer of sawmills in abeyance pending assessment of timber availability, full stop. Respondent number 5 placed on record a timber availability survey conducted by a committee constituted under the authorized officer, comma, Kurseong and Siliguri subdivision, comma, and the divisional forest officer, comma, Kurseong division, comma, wide, order dated 27/12/2022, 27, full stop. According to the said report, comma, the current timber availability from all sources is insufficient to meet the demand of existing sawmills, comma, both general and secondary, comma, within the jurisdiction of Kurseong Forest Division, full stop. Consequently, comma, the committee did not recommend the interdivisional shifting of sawmills into the Kurseong Forest Division, full stop. The petitioner had filed objection to the said report, full stop. The petitioner contends that the timber survey committee formed by the respondent is not in accordance with the wood-based industries establishment and regulation guideline 2016. That's right?
Yes.
Yes.
Full stop. The petitioner further submitted that, comma, despite the alleged insufficiency of timber, comma, the respondent continue to issue licenses for new sawmills in the area, comma, indicating the availability of adequate timber. Full stop. This court has considered the rival contention of the parties and has produced the materials on record.
Shifting rules as per the West Bengal Forest Product Transit Rules 1959, my lord. The rule 6A states that the authorized officer can pass an order for shifting, my lord. 6A, my lord.
Yes, I've seen that. That's you have quoted in page 4, para 7.
Page number 17, I have annexed the rules also, my lord.
I've seen that.
My lord. They have the power to
but that
shift,
was-
my lord, and there is no requirement of permission from state level committee, my lord.
उससे पहले
My lord.
एक और वो रिकॉर्ड कर लेना. Learned Counsel for the petitioner states that in terms of Rule 6A of the West Bengal Forest Rules 1982, the order can be passed by the
Authorized.
Authorized officer.
Authorized
is the
officer.
divisional person.
by the authorized DFO of Kurseong Division. That's what your contention is.
Yes.
All right.
And there is no requirement of any permission from. the
Anything,
state
Mr.
level.
Rahman?
I contract.
All right. In view of the so and so, this court has heard the arguments advanced by the parties and has produced the materials on record. The core grievance of the petitioner is that the respondents have failed to take a decision on the application of application for shifting the sawmill, full stop. The respondents have taken a stand that interdivisional shifting of sawmills has been kept in abeyance due to inadequate timber availability as revealed in the timber availability survey conducted in the Kurseong Forest Division. Full stop. In view of the above, comma, the court is of the opinion that the present writ petition has become infructuous, comma, as the prayer for consideration of the petitioner's application has already been complied with. Full stop. If the petitioner is aggrieved by the stand taken by the respondent or disputes the finding of the timber availability survey, comma, the petitioner is at liberty to challenge the same in accordance with same in an appropriate, comma, separate writ petition, full stop. Accordingly, the present writ petition is disposed of with the above observation. Full stop. You could have withdrawn it.
It's better.
She wants a substantive order from the court. Support. Yeah.
16.
Yes.
Well, the petition before Lordship is retired assistant engineer of Calcutta municipality.
Yes.
He's serving from 1982 and he retired in 2019.
Yes, Mr. Luxum, where is the report?
According to my report, Lordship, they have already dispersed the last 3,65,000, Lordship. This is the report, Lordship.
They have paid a gratuity of 7,30,000 and nothing else has been released. Not a single copper of pension has been released.
Give a copy of the report.
Yes, sir.
Well, this document is submitted, my lord, in July 2024, my lord.
Oh, 3,65,000
This
was paid
honorable
on
court
the.
was pleased to pass an order, my lord. Can you see the order dated 8th of July, my lord?
Yes, I'm seeing that, 8th of July.
Yes, my lord. This report has been termed as not acceptable. Because the report was to indicate as on which date, my lord, from which date they will release the benefits, my lord. That report has not been filed so far. That is the first order passed on 20th of June, my lord.
20th June?
Mr. Luxum,
My lord, in this writ petition, my lord, their prayers have been given, my lord. Let them file subsequent writ, my lord. I will
Well, this
support.
is for all these
Because-
benefits.
no, but
This is for
Yes,
the
sir.
benefits.
where is the report? You show that from the report that all the benefits have been given to him.
No, regarding it, in the last order, my lord, it was only the question regarding 3,65,000. We have already dispersed it, my
My
lord.
lord, kindly see my prayer of the petition, my lord. His entire terminal benefits are to be released, my lord. His pension has only crossed 35 lakhs of rupees, my lord, from 2019. He was an assistant engineer, my lord.
Because, my lord, this writ has been kept pending since last 2024. Last order was passed on 11/7/2024, Lordship.
Yes, my lord.
So according to the last order, we have already dispersed the amount of 3,65,000, Lordship.
The petitioner gets greedy by the day. So he is getting the money, he's pushing for it. Where is your calculation?
My lord, he is receiving pension above 35 lakhs, my lord.
Sir, today you tell me what is your due. You have already been made the payment of 3,65,000 as recorded in the
They
order.
have paid 7,30,000, my lord. That is gratuity, my lord. My
Yes,
lord, kindly
gratuity.
see the e-pension, my lord.
The
E-pension
question in
payment-
this writ is
e-pension
only
payment
regarding
order,
the
my lord.
gratuity, Lordship.
That
The
is
question-
page 21, my lord.
My lord,
This
the
is
question,
e-pen-
The question is
this is
gratuity,
e-pension-
leave encashment, everything.
yes.
So he is saying only gratuity has been paid.
No, according to the order, Lordship, we have dispersed the gratuity amount, Lordship. Let
Now
them
he's
file
saying
subsequent
according to
writ,
the
Lordship.
order.
Let them, Lordship, file a notice to the chairman that they have not received. Lordship will comply with the directions accordingly, Lordship.
My
No,
lord,
you have to
kindly
release
see
the other
page-
payments also.
Page 21, my lord.
Learned counsel for the respondent states that the gratuity amount has been paid. The said fact is not disputed by the counsel for the petitioner. He states that he has received an amount of rupees
7,30,000.
7,30,000. And how much is due?
My lord, it's more than 35 lakhs. Only pension, my lord. There are other.
He has received a partial amount of 7,35,000 in terms of his dues, his pensionary dues, as well as his other terminal benefits, including gratuity, leave encashment, group saving linked insurance, and other entitlements. Learned counsel for the respondent. You appear for the Kalimpong municipality, seeks and is granted. Respond number 4.
Yes.
Respond number 4-5, right?
4545.
Respond number 4-5 seeks and is granted.
6. I am for 6, madam.
Yes, I know. Respond number 4-5 seeks and is granted 2 weeks time to file his report by way of an affidavit. Learned counsel for the respondent state. Who appear for the state? 1, 2, 3. 1, 2, 3 local bodies also, right? Seeks and is granted another 2 weeks to file their report. Exception if any. And you appear for 6.
Yes, madam.
In this matter, the state have no partner.
It will come to the director local bodies.
State missionaries made a payment to the municipal authority. And municipal authority in their fund, disburse the.
No, let them submit a report also.
All right,
Because
then-
we also
then-
need a report
no,
from
no,
the state.
no, cut
So
that,
we have
cut that.
received or not, we have
The
to
EPPO
verify Lordship then.
EPPO has been issued by the respondent 2 months.
Respond number 3, 4 and 5 will file their report. 4 and 5 to file their report within 2 weeks, exception if any, within 2 weeks thereafter, within 1 week or 2 weeks?
1 week,
Within 1 week.
because he is without pension, my lord, for the last 5 years.
Oh, you have got enough money. Let this matter be listed after 6 weeks. You want 2 weeks, 3 weeks,
3 weeks.
4 weeks,
Grateful, madam.
4 weeks, 2 weeks, 6 weeks.
Item number 70, I would like to not press the matter, Lordship. I am the newly appointed.
Learned
advocate.
counsel, the petitioner seeks to withdraw the presented petition. The same is dismissed and withdrawn.
17.
Lordship, I have the no objection certificate from the previous advocate report.
Just give the no objection. Your Vakalatama is there, right?
Lordship, my Vakalatnama, it has been filed, but I have not received it yet.
File where?
Lordship, it has been given, the petitioner, he's in custody. So that's why it has been sent there. But
Learned counsel for the petitioner has handed over a no objection issued by the earlier counsel, Mr. Amit Kumar Kiswar. First of the same is taken on record. He states that your Vakalatnama is where?
Lordship, my Vakalatnama itself, I have not received it yet. It has been filed today.
File where?
Filed, Lordship, the custody of the petitioner is custody in Siliguri Correctional Homes.
Will then you see without the Vakalatnama, it's
Lordship, then kindly give me 1 day's adjournment, I will file it the next day and give it the next day.
not.
Oh, that.
High score return. You file a Vakalatnama
Then kindly give me fix it Monday, Lordship, not today.
Monday.
For the petitioner.
Let's see, if I'm for the respondent.
He's claiming family pension and another pensionary.
Mr. Singhania, you are appearing for
Lordship, respondents. 1, 2, 3, your lordship.
family pension, decide his representation.
Lordship, there is a dispute between two wives.
I know.
And the suppression of materials facts is also there. Title suit, they have filed the title suit, your lordship. But it was against the petitioner, your lordships. I have the documents. As a respondent of 1, 2, 3, we have the no objection to disburse the payment. But there is a dispute between the legal heirs. There is a several wives and legal heirs.
Can you decide the representation of the petitioner?
Lordship, it can, but your lordship, in page 21, last line, your lordship, the answer is the same. There is a dispute between the wives. Page 21, last, your lordship, para 7. That it is further requested that the pensionary benefit and other benefits be not paid to anybody without prior intimation to the petitioners. Now there is a title suit, that is a suppression. Lordship, this is a judgment. This decided against the petitioner. In
So
the
what
title
is-
suit that decide the legal heirs.
What is this?
Lordship, that is the judgment of the legal heirs. Now they subsequently filed the appeal and withdrawn.
This is not for claiming the pensionary, this is my entitlement to.
Yes, yes, as a legal heirs, declaration of legal heirs.
Are you a legal heir?
I am a legal heir.
But title
I am
suit
a
is
legal
that,
heir.
What is this? What is this title suit? Why you have not placed it on record, sir?
and file an appeal, subsequently
Why
withdraw.
you have not placed it on record, sir?
I have, in such, I filed a civil suit before the competent civil court.
I am saying, sir,
What is the result?
why you have not placed it on record?
Lordship, at the time of filing, I was not having a copy of it, but I mentioned it in my petition.
Lordship, I have one suggestion. Lordship,
Yes.
they file and obtain a succession certificate, incorporate the opposite parties in the succession. Then your Lordship, after succession certificate, you have deserves the learned court.
Why don't you get a succession certificate?
Incorporate the name of respondent number 4, 5 and 6.
You have to get a succession certificate, then only they can
Lordship.
miss.
Let them consider my representative and say that.
No, they will,
What is the
the
result?
point of unnecessary?
Unnecessary.
What do you want? Dismiss it or what? This will harm you.
Paying for let them consider my representation and pass.
That is the
Can't be done. Get a succession certificate, they'll consider your representation.
Whatever they will decide, they will decide.
what is that? Lordship, result is the same.
Learned counsel petitioner which seeks to withdraw the present writ petition.
Lordship, record my submissions. Lordship,
No, I'm not. Why should I prejudice them unnecessarily?
Lordship, Lordship,
Dismiss as withdrawn. I don't want to prejudice them.
Lordship. Lordship, I can get back the title suits.
Yes.
Lordship, get
If I
back.
prejudice them, then they will not get anything. Yes. Next.
90. Lordship, this is a matter of an application made before.
Passover, Thursday. We'll have it on Thursday. You have added the respondent?
Yes, yes, Lordship.
Thursday. Yeah, they added it. Thursday. Thursday.
Deeply.
What is the issue?
It's an application under section 14.
Yeah.
And while deciding the section 14 application, the learned district magistrate has observed the power of learned debt recovery tribunal and has adjudicated the entire thing,
Who
the
appears?
entire issue.
Proceedings is pending before the DLP and not the component.
That's all right. We are only concerned with 14. We are
Yes.
not concerned with, we are only concerned with the power of the district magistrate, nothing more.
They denied the section 14 application, rejected the section 14 application on 5 grounds, thereby deciding the whole securitization application that is pending before the learned debt recovery tribunal. First of all, they made
You appear for the DM.
Yes, Lordship.
They made the.
What is the role of the DM in 14? To satisfy himself.
Ministerial power. Just ministerial power is there, Lordship. If you Lordship can speak, state court of judgments are there, Lordship.
Thursday.
Deeply aware, Lordship.
ये दे देना फाइल. You go back.
20.
Yes.
I'm for the petition.
Yes. Have you filed the report, Mr. Paul?
Yes, he had filed the reports, we had filed the exception also. Petition.
Yes, sir. Yes. So this is the argument matter, huh? When shall we have it then? Will take some time. Wednesday, Manoj? Wednesday? Tuesday, Wednesday? We'll keep it for hearing. Tuesday. Tuesday? Tuesday. 20. ये क्या नाम है इसका? मैटर दीपशिका साहा. Okay.
21.
Your Lordship kindly sees the orders dated 11th of March 2025 and 26th of April 2025. Passed by the Honorable Coordinate Bench, my lord, the state was directed to file a report in the form of an affidavit.
We have received the report, my lord, it is yet to be affirmed on affidavit, my lord.
There was a date, my lord, on 25th of April, that 8th of May it has to be filed.
We have received.
Learned counsel for the respondent seeks and is granted further time of, she states that she has received the report. She prays for one week to file the same.
There was a liberty to file exception.
She seeks further extension of 1 week to file the same. Full stop. Let the report be filed within a week, exception to the same, if any, within 1 week thereafter. List before the next available. And these could have been disposed of, Ms. Sarkar. These are short matters. Yes. Same, right?
No. Earlier, my lord, service was incomplete. Now I have completed the service. But subject to correction by Lordship, my lord, a report might be called for. Here again also.
My lord, this is pending before the technical secretary for his disposal. My lord, if direction may be passed upon him to dispose of the matter. My lord, I have clear instructions that the matter is pending before him for disposal.
My lord, I have provided electrical installation. My
Where's, you must have made a representation. Will
Yes, so that may be considered a matter. Representation, my lord, page 67.
67. Detailed representation.
we can dispose it off.
If the representation consideration, my lord.
He is ready to do it.
May be considered.
Tell me what you want.
ওটা তো মানে এখন ওর কাছে এন্ডিং আছে করে
Very well, my lord. Then kindly directs them to consider my representation, my lord.
This is petitioner has preferred the present writ petition seeking
But prayers are
seeking release of payment of rupees 53 lakhs 15,220 for what is the work?
I have done, my lord, electrical installation work for
Providing the logistics support as well as, no, this is what electrical work.
electrical installation work, my lord. During West Bengal legislative election.
For providing, where is the, just a minute. For providing logistic support for ensuing assembly election in the West Bengal 2021. Page 19, right?
Yes. Page 16 onwards, work orders were given, my lord. 16, 19.
Ethical work. क्या लिखा है? for carrying out temporary electrical work at different schools. Under Banarhat PS, Dhupguri PS, Haldibari PS, Kotwali PS, Mal PS, Mainaguri PS, ये यहाँ से उठा लेना. And Rajpuri PS for accommodation of CAPF and security lights with logistic support for ensuing assembly election in West Bengal 2021. Full stop. It is the case of the petitioner that despite carrying out the said work, the payment has not been released. Partial payment released? Petitioner that partial payment has been released, but he has not been given the entire payment. Full stop. He has made, counsel for the petitioner states that he has made several representation, but the same has not been
Final representation is
decided.
Page 69, my lord, where I've given. the
But he has
chart.
not heard anything from the concerned department. Learned counsel for the respondent state appears and states that he is ready and willing to decide petitioner's representation dated 3/3/2025. Full stop. Learned counsel for the petitioner states that he shall be satisfied if the same is decided within a time-bound manner. Full stop. In view of the statement made by the counsel for the parties, this court directs the respondent number
6 months.
Respond number 6 to decide petitioner's representation dated 3/3/2025 within a period of 6 weeks from the date of communication of this order, after granting an opportunity of personal hearing to the petitioner by way of a speaking order. Full stop. With the above direction, the present writ petition is disposed of.
Great.
23.
23, my lord.
Similar matter, my lord.
Here I appear election to India, my lord.
Here
It is 23, my lord.
the report was filed, my lord, and my amount has been admitted.
My lord, the technical, it is in the end of the technical secretary to dispose of the case of the petitioner, my lord. On the last occasion, we have filed a report.
Kindly takes up the report, my lord.
Yes.
My lord, report.
This was for Lok Sabha election, my lord.
So they are admitting it.
Yes, my lord.
My lord,
The report says so, my lord.
yes, my lord, admitting but right to the decision is to be made by the technical secretary PWD. He is not a party in this petition, my lord. My lord, let him dispose of this communication between the respondent was 6 and.
May I make one humble submission, my lord?
Yes.
May I be given liberty to add the particular office party? And then, my lord, mandatory order.
Learned counsel for the respondent states that who's the necessary party?
My lord, the technical secretary, public works
The
department.
technical secretary, public works department,
My government of West Bengal.
government of West Bengal is
Law. I'll give them law and arbitration, sir.
just give the so and so is a necessary party to the present writ petition. Full stop. Learned counsel for the petitioner shall make such and such a party respondent to the present writ petition. Notice shall be served upon the said newly added respondent. Let this matter be listed. When do you want?
Next week, subject to convenience by all.
Yes, my lord. He just has to decide this.
So you will appear for him only.
I'm appearing for yes, my lord.
So next week we can have it.
Thursday?
Next Thursday. You take instruction if to
I'll come back.
Thursday.
আছে তো প্রথমটা তো পুরো টেকনিক্যাল
24.
No, there was direction.
Whenever I am for this,
There was direction to submit a report.
my lord, 24 I am for December.
Yes.
My lord, about my lord, my lord, my lord, my lord, my lord, my lord, my lord,
I shall serve a copy
as
of
per
the
PSP,
my lord.
PSP permit to the school permit, my lord. My lord,
I can't hear you, Mr. Das.
matter about transfer the PSTP permit to school bus
Mr.
field,
Das,
my
I
lord.
can't hear you. Where is he? I can't hear him. Tell him to have a better connectivity. Learned counsel for the respondent number 2 has filed his report in the form of an affidavit. Full stop. The same is taken on record. Full stop. Learned counsel for the petitioner seeks and is granted liberty to file exception to the same.
Lordship, supplementary affidavit will be taken.
No, they were supposed to file it prior to my filing my report, but they have not used that. They have
Lordship,
submitted later.
we have
By then,
some
the
of
affidavit was
state
prepared,
laws
my lord.
indicating the numbers, vehicle numbers, which has been transferred to the.
My lord, on earlier occasion, I have filed my lord supplementary affidavit, my lord.
Supplementary affidavit is taken on record as
Already filed, my
is taken on record as directed by this court by disorder dated 3/4/2025 is taken on record. Full stop. When will you file your exception? How much time?
My lord, within 7 days, my lord.
Exception, this kind of report seeks and is
Within
granted
1, my lord.
1 week time to file his exception to the same list before the next available certificate.
Oblige your lord. Copy of report handover, my lord, to my junior, my lord.
एक मिनट फाइल दिखाना.
Copy of, 1 copy report, my lord, report of 1 copy to my junior, my lord.
More of a private dispute between the parties. What does the state has to do in it?
Lordship, this matter, we are agreed with the RTA Coachbihar, Lordship.
My lord, another PSTP permit transferred in school bus permit, my lord. I have mentioned in my affidavit, my lord.
Next.
Grateful.
Oblige your lordship.
My lord, I am the petitioner, your lordship. This is a illegal construction done by the Mathawanga municipality on my land, your lordship.
I am the state respondent, lordship.
You appear for?
State respondent,
Who
lordship.
appears for that?
Mr. Ghosh, lordship.
Who? Is not here. Serve him, get him on Wednesday, not today.
Much of that, your lordship.
The petitioner, your lordship, and led by my senior, Mr. Dheeraj Dakote in this matter. The lordship, we have to take some instructions with regard to the petition.
No, not today.
From the petitioner.
Learned counsel for the petitioner seeks adjournment. Praise for let this matter be listed before the please.
At 27, my lord, I am for the petitioner, my lord. At 27, my lord, I am for the petitioner, my lord. And here, my lord, the petitioner made an application seeking, my lord, inter-district transfer, my lord, on self-medical ground, my lord, page 29, last annexure, my lord. The petitioner is suffering from, my lord, cardiovascular problem, my lord. And the distance between the school and the petitioner's residence is 366 kilometers, my lord. That may be considered by the board, my lord. Board is the authority to consider the inter-council transfer, my lord.
Yes.
Sure, I am very for honor of the estate, Lordship, I am not present in the board, Lordship.
Who's for the board?
The right council, Lordship.
But my instruction is existing start upon the board, my
Get
landed.
them Wednesday, not today.
My application for restoration.
Restored. What is there? Who has objection in it? Anybody objection?
No, I'm also because the tenure is quite huge.
Oh.
4 years, 9 months, 27 days.
Oh.
you can apply before.
Why that delay?
It was filed when there was a confusion between the principal bench and the circuit bench was newly set up. It was filed in the principal bench, it came here to the circuit bench, thereafter, the file was lost. The client also lost touch with the client. It can be
Petition-
restored, but let the.
No. Let them file
Yes,
reply.
you do suggest that.
Yes. Learned counsel for the petitioner has filed an application for restoration, full stop. Learned counsel for the respondent seeks and is granted 4 weeks time to file reply to the same. Rejoinder if any within 1 week, list after 6 weeks.
I'm out.
Thank you, Mr. Mishra, for pointing that out.
29. My lord, there is a petition for restoration. Actually, on the earlier occasion, the petitioner is a woman. The learned lawyer, the earlier learned lawyer, he returned back the brief. And by this time, his husband got sick and he was unable.
Sir, what are you seeking? What do you want?
Restoration, my lord.
Restoration.
Matter was earlier dismissed.
Dismiss.
I am for the respondent National Highways.
Any objection to restoration?
Just a copy of the petition maybe, sir.
Give a copy of the
Already
Sort
I
of the
started.
same. Petitioner has filed the application for restoration. In view of the submission and the grounds, restoration application is allowed. You may open it.
आगे दिए কিন্তু
उसमें एक line add कर देना. Respondents have no objection to the said restoration application. In view of the same, the restoration application. Counsel for the respondents have no objection to the said application. The same is allowed. So दो ground दोगे सौरभ. For the reason stated in the application and since the respondents have no objection to the said application, the same is allowed.
Yes.
30.
This is not my responsibility. It can be restored. But there is a can 1 and there is also can 2 because there was a 4-day delay in filing the restoration.
Can 1 and 2 both allowed. Delay of 4 days is condoned. Can 1 is allowed. Grounds and the same, no objection from the respondent. For the grounds stated in the application and no objection on behalf of the respondent. Application is allowed. Tuesday. On request of Ms. Singh, the matter is listed on Tuesday. See that not today, Gato, Tuesday now. Tuesday. Tuesday.
32.
Readings complete?
I in fact started that day. What you of the learner ASC was.
ASG was, okay. We'll hear it. Yes. Right. Learned ASG is here?
Short pass over your worship.
I can start.
Just 5 minutes, only just 5 minutes.
Yes. Start, Mr. Mishra.
First, if I can have one straight away on page 25 numbers, 2525, it happens to be my first share.
Yes.
For the first time,
You had shown Roman 7.
Yes, ma'am. Roman 7.
B- BRTC.
So there is a BRTC. So there is a basic recruitment training course that every incumbent has to complete. That training course not has to be completed within 2 years and maximum of 2 opportunities are given. So for example, if I join on 2025, 1st of January, then by 2027, I have to complete the BRTC and I have to complete it in maximum 2 opportunities. Now, if I can have notes from
Yes.
But I've gotten information yesterday night from the department that similar point, if the person's dismissed from service on the injury, there are 5 SLPs pending for the honorable. I can furnish my lord the entire details. This is just I intimate the honorable court and my learned friend, so we tread the ice process.
So then we'll wait for the outcome if the issue is the same.
No. In fact, from one of our High Court lords, there was a similar case that was decided.
Biplab
And I will
Burma.
show that judgment.
Biplab Burma. Biplab Burma after
That SLP they preferred and that SLP was dismissed.
Mr. Mishra, please follow what I'm saying.
Yes, sir.
I'm not on Biplab Burma. There are 5 SLPs pending as good as 5 SLPs.
Now, what are the issues of that?
Same matter. Injury during BRTC, dismissed from service.
So even in this case, they can go for an SLP. The order would be there.
No, why should we unnecessarily waste Mr. Mishra?
No.
If that is the issue.
We are not aware what kind of SLP he is talking about.
You-
What are the facts
These are
there,
the-
what are the issues there.
No, my lord, kindly read the letter. I may read out aloud.
Give a copy to Mr. Mishra.
Yes.
Yes.
My lord, please take from paragraph 3, further petitioner in Prakash Kumar Rai was enrolled in SLP and detailed for BRTC, which was scheduled to be held at RTC's SLP Gorakhpur, while undergoing sustained injuries left leg. So all these matters are pending with the Honorable Supreme.
In paragraph 2, Milords, in the first page, they talk about Biplab Burma.
Yes.
case. This SLP has already been dismissed.
So what are the next, Mr. Mishra?
Huh?
Give a full picture to the court. In
No,
the matter
I'm-
of Ravi Ranjan.
I'm starting from the first page. I come to paragraph 2.
Yes, it is there.
And then, so this SLP was already dismissed.
Then next.
Further petitioner Prakash Roy was enrolled in SLP on such and such. Detailed to-
Well, the aforementioned petitioners in serial number 4, petitioners have filed SLP before the Honorable Supreme Court of India to challenge the judgment pronounced by the Honorable High Court of Delhi. The details are SLP number so and so. Dipankar Kumar Singh, Akshay Dinkar Hiwale, Anmol Shamram Khokare, Ravi Ranjan Kumar and Vishu Gupta.
No, this is the instruction that has been given in the case of one Prakash Kumar Rai by the Deputy Jack Frontier Headquarters SSB to some Anil Kumar who happens to be the ASGA. In the last paragraph, it says that the submission made by the petitioner Prakash Kumar Rai in the instant matter, which is the matter pending before Jharkhand High Court, referring to a similar case that was dismissed by the Honorable Supreme Court, which is my case, Biplab Burman, is not applicable to the present petition. As the Honorable Court, this is an opinion that I
I don't know why Mr. Mishra.
Mr. Bazubda. Unless until, see, the issue is very different. I don't know what exactly is before the Supreme Court. And even if the issue is there before the Supreme Court, in one of your petitions, you have lost that, right? That Biplab Burma. So that issue has already been decided by the Supreme Court. You show me the order of the Supreme Court or the petition which you have filed before the Supreme Court. What is it?
In these cases.
Yes. Because your instruction itself says that in the facts of the present case, even this is not applicable. This
Mr. Mishra, I think the Honorable Judge asked me to answer.
Sir, please, sir.
No, my lord, kindly takes Biplab Burman. I know this will confuse. My lord, kindly comes to Prakash, then comes to in Ravi Ranjan.
Yes.
He was enrolled in SLB on
Yes.
31A217 and detailed for BRTC at RTC SSB Alwar. While on BRTC, he felt pain in his left leg. Later on, it was diagnosed and he was suffering from ABL left femoral head. He was declared as low medical category.
Mr. Mazumdar, I will just go by instant matter. Prakash Kumar Roy is factually identical and similar to Ravi Ranjan, right?
But
And
different-
factually dissimilar to Biplab Barman, with whom petitioner is claiming parity. Now, wherever the instructions are for this matter,
Yes, sir.
so we will see in the facts of this case, what is the case all about?
In this case also, he got injured during BRTC.
We'll see factually what is there.
No, my lord, I am not asking the court to shut down the hearing. I am just informing the SLPs are pending. Now,
Yes.
if your lordship is there, let me send my
Yes, start,
I will
Mr.
reply to you.
What I was saying from page 25 was that.
What are these orders of Delhi High Court? You have seen it?
Lordship.
Have you
No,
gone through these orders of Delhi High Court?
Yes, that has been referred to and I will refer to those judgments.
Ah.
It is all.
These judgments.
So what I was saying was,
These judgments.
you will do that. What I was saying was not that this BRTC has to be completed within a period of 2 years and there is a maximum of 2 opportunities. Now, before I proceed further, notes, how a person is recruited is also important. If I can have notes for a moment on page 46. There is a particular level of a medical fitness that is required because this is a very disciplined force. And in a disciplined force, a person has to be perfectly fine in order to join the force. At page 46, you will find that there is a medical fitness requirement for every personnel that is there at the time of recruitment itself. This has been very peculiarly designed and it is named as SHAPE. Now, the definition of the SHAPE is that S is for psychological, H for hearing, A for appearances, P for physical capacity, and P for eyesight. Somebody has to qualify on all the 5 things to become a SHAPE 1. So if all the 5 components are good, it is called SHAPE 1.
Yes.
If there is a deficiency or discrepancy in any one of these, if the person has a psychological problem or if the person has a hearing deficiency, then in that case it will become SHAPE 2. So that is the basic difference between the SHAPE 1 and SHAPE. Now, if I can have my lordship at page 40. Page 40, lords collectively sums up each and everything that is part of the writ petition and is part of the case. This, my lords, is a fax message.
Yes.
So every incumbent who joins the SSB has to mandatorily and compulsorily go through the BRTC. How the BRTC happens, for example, I join the 42nd Battalion or the 50th or the 52nd Battalion. Then my principal battalion has to sponsor me for the BRTC. BRTC happens at a fixed place. Each battalion, from there the personnel, they are sponsored to the BRTC, and after the BRTC is complete, these personnel who has completed the BRTC are taken back to their principal command. Here in yours is a message, a fax message that is written to the DIG and that is also carbon copy to the commandant of the force headquarters. It says it is intimated that UIN 14131010 RCT GD Himanshu Kumar, which happens to be me, joined SSB on 20th April 2021 at 39th Battalion SSB Palia in the strength of 53rd Battalion Shimulbari Falaka. He was undergoing BRTC at designated training camp 39th Battalion SSB Palani UP with effect from 10th of May 2021. On dated 6th of 10 2021, which happens to be 6th October 2021, he had sustained injury in his left eye by an extracted case of an insert rifle of other training during midterm test filing at filing range, Shahjahan, while discharging government bona fide duty. So what actually happened was this BRTC is a 44 weeks training course. During that 44 weeks, it sums up to 10 months. During this 10 months training course, there is different kind of training that happening. There is a written examination also that happens, and side by side there is a training also that happens. The training also includes the firing training. While the firing training was happening, my co-trainee was doing the firing on my left hand side from his the insert rifle and extracted cartridge which hits my left eye and I sustained injury. As per COI report, there is a COI that happened. So in each case, there is a court of inquiry that has to happen. anything happens, then there is a court of inquiry that has to. The injury sustained by such and such RCB Himanshu Kumar 53rd Battalion attributable to government service while discharging bona fide government duty. The said official could not be sponsored for BRTC because I had an injury, therefore my battalion did not sponsor me. The said official could not be sponsored for BRTC due to medical category shape 2. So if I would have been shape 1, I would have been referred to BRTC training. But because there was an injury in my eye and because shape also includes the eyesight as E, therefore I became shape 2. And the moment I was shape 2, I was not sponsored. Further, it is intimated that after regaining medical category shape 1 on 8/9/2023, such and such Himanshu Kumar of the battalion has been sponsored for BRTC commencing from 4th of December 2023 onwards at RTC SSB Hull. After completion of 2 years of service, as the proposal for granting of exemption in his favor for undergoing BRTC after completion of 2 years of service was under consideration at the higher headquarters. Because I had to complete it within 2 years, but because of certain eventuality, I couldn't complete it within 2 years. Therefore, a recommendation for extension of the 2-year period was pending before the frontier headquarters. Now what happens? Now the commandant, personnel to FHQ headquarters, SSB New Delhi, by their wing fax message such and such, dated 18th of March 2024, has directed to take necessary action under the provision of the RRs of the city offer of appointment and joining order. As per the offer of appointment joining order as well as RRs of city GD, it has been mentioned that she will have to undergo and qualify the basic training course being conducted by Sarkar Sunabal within a period of 2 years from the date of appointment. Not more than 2 chances will be given for qualifying basic recruit training course. Failing his or service will be liable to be terminated. In view of the above, it is requested that the said official may kindly be withdrawn. So in the midway of the BRTC seminars, I was withdrawn from the BRTC training course immediately and relieve him with the direction to report at 53rd Battalion, Simulbari Falakata with squad. So there was a squad that was sent. It was not an honorable withdrawal. There was a squad which was sent. The squad was asked to bring me back, which is being sent from 53rd Battalion. For further course of action at this entity, message for SSP Jalpaiguri request approval, detailed of a special messenger from this battalion. This letter is being written by the command, who have been written my command. So I couldn't complete the first PRTC because I sustained the injuries. Thereafter, when I regained the shape 1 position, thereafter I applied or I was sponsored for the second PRTC. But in the midway, when it was only on the 20th or 22nd week, I was pulled back from or withdrawn from the PRTC. That was the nutshell of the facts that are there. Now, my lordship, if I can have yours for a moment on this 33.
Yes.
At this 33 minutes, there is a communication that has been sent by the deputy commandant. Oh, I'm so sorry. 34 can be referred. 34 and 35. First note 35.
Yes.
There is a report from the Sankar Netralayam. The last line says that I am fit to join the duty. Even in 34 notes, which is again a letter dated prescription dated March 29, 2023, I was fit to join the duties. Now what happens? Note page 43. There was a show cause that was issued to me. Once I was pulled back from the BRTC and brought back to the 53rd Battalion. The show cause says, show cause notice for termination of service on the ground of non-compliance of BRTC within 2 years from the date of appointment under Rule 26 of the SSB. So the rule mentioned here is 26. Thereafter, the facts of the case has been called out. At the second page, internal page 2.
Yes.
It says, and whereas you were detailed for the first time to undergo BRTC being conducted at designated training center 39th Battalion Palia with effect from such and such, but you were relegated from the said course on dated 31/1/2022 as you sustained injury in left eye by an extracted case of Punsas rifle during midterm test at firing range Shahjahanpur, due to which you remained absent from training on medical ground. So the reason why the show cause is being issued to me, Lord, is because I was absent from the training ground for medical reason. for the 30 days in accordance with para 5 of the revised regulation 83 and the BRGs. Now, if I can have my lordship for a moment on the act and my lords the SOP. First, my lords, we will look into the SOP. This SOP, my lords, has been this is a standing order dated standing order number 83 of 2024, dated 16th April 2014, wherein all the guidelines with respect to the BRTC have been clubbed together.
Yes.
How the BRC will be conducted, how the first term would happen, how the second term would happen. Another standing order, if I can have my lordship for a moment, my lords, at page my lords, the 3 Roman 1, and then we will look at 3 Roman 2 and then 3 Roman 3. I just wanted to point out what are the different consequences that happens if a person leaves the BRTC at different stages. So first Roman 1 at page 88, my lords will see, is failure to qualify final examination. What happens if somebody does not qualify the final examination? Because there is a written test also that is happening, and side by side there is a physical test also that is happening. So in case of a failure to qualify the written examination, final examination, lords, Roman 4, last line, he would be terminated because he is unlikely to become an efficient member of the force. So he is not suitable and then he will be terminated. In case of 3, which my lords is important in my case, what will happen if somebody has suffered a major ailment or an injury and because of which he is not able to complete his BRTC? Roman 3, my lords, is titled as failure to continue training on account of major ailment or injury.
Yes.
In case the training suffers major injury or ailment and there is no sign of improvement or recovery even after treatment, and the trainee is not able to undertake further training due to such injury or the ailment and declared unfit on medical ground by the medical board, action to board out him. So there is a provision to board him out.
Yes.
Now, what is the difference between a simple termination ipso facto and a boarding out? In case of a boarding out, lords, there is a board that has to sit up. The composition of the board is given. The board decides whether the person can actually be kept in under the force or not. In case if the board turns out, then there is an EOP. And EOP, lords, is an extraordinary pension. That extraordinary pension is paid to the person in company. But in other cases, that extraordinary pension would not be paid. Then, lords, next page. What happens if somebody does not complete the training on medical ground or any other reason or ground? If there was any other reason why I could not have completed the training, then what would have happened? 5A, if any recruit constable remains absent for 30 days, because in the show-cause notice there was an allegation of being absent, remains absent for 30 days at a stretch or even at different spells during the course, he may be relegated to the next junior batch immediately. Total period of absence should not exceed 30 days. If any recruit constable remains absent from training for 30 to 45 days, then lords, in that case also he has to be referred to the next batch until and unless he is declared fit.
Yes.
7 is also important. 7 says discharge from service on grounds of unsatisfactory progress in training. What would happen if my training commandant would have said that my progress was unsatisfactory? Action will be taken as per Rule 18(3) and Rule 22 for termination of service. Now, my lords, I would again take my lordship the show-cause notice that was issued at page 44. In the 3rd paragraph, my lords, there is an allegation against me. The 4th paragraph says, whereas as per clause 3, para 3 of the appointment order such and such, I had to complete the BRTC within 2 years or by 2 chances, which I failed to do. 5, whereas you have completed 2 years of service on such and such and not yet completed the BRTC being conducted by Shastra Simawal within a period of 2 years from the date of appointment. Therefore, after 5 minutes, it is incorrectly numbered as 10. It should have been 6. Therefore, The undersigned is of the opinion that you have not completed the BRTC within a period of 2 years as per the provision contained in the recruitment rules for the post of constable GP in SSP after appointment. So your services is liable to be terminated.
Yes.
If you have anything to present in your defense against the proposed termination from service, you may do so within 30 days.
Yes.
Now, this, my lords, has been issued under Rule 26. Rule 26 read with para 5 of the SOP.
Yes.
Para 5, I have just showed to my lordship. Para 5, my lords, nowhere it says termination. Para 5 simply says that I have to relegate it to the next batch that is available. Let's come to Rule 26. Assuming that it has been issued under Rule 26. Termination of service of enrolled person on the ground of unsuitability. It is only on the ground of unsuitability. This would not have been issued to me. The correct section, my lords, in my case would have been 27, Rule 27, my lords, which applies in case of physical unfitness, wherein EOP, the extraordinary pension is available, but under Rule 26, my lords, the extraordinary pension is not available. But still, if it has been issued under Rule 26, then what would happen? Where a commanding officer, not below the rank of commandant, is satisfied that an enrolled person is unsuitable to be retained in the force, then he will so inform such and such and such. Provided that ABC may not apply to the commanding officer, then what he has to do further such the enrolled person shall be so informed. So I had to be a SOCOS has to be issued. That was issued. Furnish upon the particular that was given to me. Then paragraph 2, 26(2), my lords. After considering the explanation, so once I give the reply to the SOCOS, thereafter what will happen? After considering the explanation, if any, the commanding officer not below the rank of commandant may call upon the enrolled person to retire or resign. I will be asked either to retire or resign. In both the cases, my lords, the extraordinary pension would have been available to me. On his refusing to do so, the enrolled person may be compulsory retired or discharged.
Yes.
Even if I would have been compulsory retired or discharged, then also, my lords, the extraordinary pension would have been available to me. Nothing but that's what happens. What actually happens is, I reply to the SOCOS. I reply, my lords, to the SOCOS at page, my lords, 49. To the command. I narrate all the facts that are there. Paragraph 6, my lords, is of some importance.
Page?
Page 4949, lords, this is annexed at P9.
Yes.
That's at the commandant. I'm reading paragraph 6, my lordship. That's at the commandant of the training center applied SOP 83 while relegating me for the training. But now the commandant 53rd Battalion has applied Rule 26 of the SS rule in serving notice upon me, which are contradictory to each other. The part application of one rule and part application of other rule in same case amounts to violation of natural justice. Then, my lord, 7.2. The SSB has already applied Rule 24 upon one such and such. I therefore pray that if I am found unfit for service by a medical board, the same provision under Rule 27 may be extended to me, as the essential service period of 10 qualifying years of entitlement of extraordinary pension has not been waived off, and therefore I would become entitled to extraordinary pension. And 8, that sir, I implore before your highness that my service may not be terminated in any other manner. This is the reply that I give. Now, after the reply, what was required to be done under Rule 26, because the SCM was issued under Rule 26? Because I may be called upon to either retire or resign, and upon refusal, either compulsory retired or discharged. Nothing happens. What they do is they pass an order at page 51. Straight away termination from service. Without giving me any option. Not page 53 is relevant. Para 8. Whereas you have submitted your explanation, dated such and such, which is not justifiable and is found to be unsatisfactory. There is no explanation why it is not justifiable. There is no explanation why it is unsatisfactory. At least one or two more lines they could have written here. Then, now the undersigned being competent authority in the instant case, examining the entire circumstances with reference to prevailing instruction and provision and such, Himanshu Kumar failed to qualify the BRTC within 2 years from the date of appointment. Hence, he is unsuitable to retain in the service under Rule 26, again 26, and thereby terminated from service with effect from 11/5/2024. And accordingly, I was struck off from the strength of the battalion from the same.
Yes.
Thereafter, my lord, there is a provision for the statutory appeal. My lord, page 54 is my statutory appeal that I have preferred.
Yes.
That statutory appeal also, my lords, I have detailed everything, said that even if I have to be bowed out, then in that case, my lords, the medical board should have been appointed and Rule 27 should have been applied in my case, which, my lords, was discarded by way of a 2-page, 1-paragraph order, my lord, page 56 and 57. Nothing considered, cryptic order. Now, therefore, the appeal has been examined in detail, and such, who was appointed on such and such, has been correctly
Now
terminated.
show me the law.
Finding. Page, my lords. It starts, my lords, the order of the appeal, my lords, starts at page.
That I've seen. Show me the law.
Yes, sir. Now, what happens in cases like, first off, my lord, since much has been talked about Biplab Burman, which was also a case that we did. If I can have my lordship for a moment on the brief order of Biplab Burman. What happened during the report and how this issue of application of Rule 26 and 27 was decided by the learned writ court in that case.
Which para?
My lord, page 5, the
Page
relevant
five.
portion starts from the middle
The
para.
dispute in the
In
instance.
this case, my lord, the person has suffered a leg injury during recruitment training. The dispute in the instant matter relates to the petitioner being discharged from duty on the ground of being found to be medically unfit, but more specifically under Rule 26 of the notification circumstance, which requires candidate on direct appointment to qualify BRTC within certain such period. Two issues arise from the document on report which needs to be considered. Thereafter, my lord, the facts have been narrated. At page 7, my lord, the report says the second issue is Rule 26, which has been relied upon, confirming such and such, wholly relied. Rule 26, namely, there is no provision for retaining a candidate in the service of SSP who has not completed. On perusing the relevant rule, this court is of the view that Rule 26 must be read conjointly with the attendant facts in respect of a candidate. It cannot be applied without due assessment of facts which may have interfered with the applicant undertaking BRTC within 2 years from the date of applicant's appointment. In this case, the admitted fact is that the petitioner suffered serious injuries in the nature of fracture in the hip, and therefore, my lords, it was directed that Rule 27 should have been applied instead of Rule 26. Then, my lords, they went to appeal in this very case.
Yes.
The division bench, my lords, the division bench, my lords, at page 2 and 3 refer to Rule 26 and 27.
Yes.
And after referring to Rule 26 and 27, and my lords, there were cases cited from both the sides at the bar here. Even the learned DSG cited certain cases, and we also cited certain cases. Our division bench, my lords, it relied upon the case of Rajpal Singh,
Yes.
which I will also be showing to my lordship. And it held that in cases like these, there should be an inclination wherein Rule 27 should be applied instead of Rule 26. And a duly constituted medical board should be there. It should be the board that should decide whether a person is physically fit to be retained in the forces or not.
Para 20.
Para 20. And the judgment that has been relied upon, Lord Rajpal Singh is also with me, Lord. There is a Supreme Court judgment. This, although Lord, it emanates from the Army Act, but the act, all these acts, Lord, they are pari-materia to each other. Paragraph 24, 25, and 26. In fact, the Supreme Court has also gone to the extent of saying that if a person is injured, then at least a sedentary duty must be given to them rather than just throwing him away on the ground of termination. There should be at least an opportunity that should. So my case, Lord, is that even if it was my case, even if their case is of Rule 26, the Rule 26 was not applied. half-heartedly. I was not given an option, and based upon that option, I was not asked whether I would like to resign or upon my refusal, they should have compulsorily retired or discharged. Therefore, even 26 was not
They carried this to Supreme Court, right?
They carried this to Supreme Court. The SLP was dismissed. That is SLP.
What else?
No, that is all that I have.
Yes, Mr.
Unfortunately, Mr. Mishra was not in the first round of litigation in Viplab Bhavan. And fortunately, I was also the entire scenario.
Yes.
But then one salient difference between the facts that is we are attending in this case and that of Viplab Bhavan. Viplab Bhavan was never sponsored for the second time for PRS. He sustained a leg injury where a steel shaft was inserted. And his one leg got shortened, so he was never been able to be sponsored for VRTC. What happened is this unfortunate young man was given the duty of collecting the discharge cartridges. When he was collecting the cartridges, one of the inserts went cartridge, sprang out and struck him on the eye. He was treated in the and when he was found from again to be likely to be complete the PRT training, he was sponsored with the anticipation, though it was beyond the period of 2 years, that the uppermost level is considering to relax the 2 years line. But unfortunately, the government, Home Ministry decided as a policy not to continue. No, my lord, it is needless to remind your lordship that in a judicial review, all infractions does not invalidate the decision until a grave prejudice is caused to the petition. My learned friend is arguing that he was whether he was given an option to resign or thrown out. But that I have to find out from the I have to find out from the right. In all probability it was given, though it is not reflected in the order. So whether I agree to be let out of the door or I have thrown the door, the result remains same. Your lordship, the petitioner in all three his argument has not been able to bring out any procedural lapse by the department.
No, he shows the procedural lapse in applying Rule 26.
Now, his argument is that because I got medically unfit, so you apply 27 on me. But department said we are not on your medical fitness or unfitness. We are simply saying for whatever circumstances you could not complete your training within 2 years. Because, my lord, he was re-sponsored for the second time in the anticipation that the Home Ministry may be lenient with the policy decision and allow the persons who could not complete BRT training within 2 years for some good bad thing. Not that he was shown the door on medical unfitness. Because it is their petition they say, man. And if they rely on people of Burma, they have to give up their prayer one. Because people of Burma was never reinstated. And in any way, my lord knows it cannot be reinstated until that is there. No, they say that 26, but the department says he was, my lord, this is the catchment. He was again sent for BRT training when he was found eligible, though beyond the period of 2 years. And it is his case that with an anticipation that the relaxation may come in. But the relaxation was not given. So automatically, there the door got closed. Had the relaxation been given, the case would not have been. Had the Home Ministry considered and said, no, we are relaxing the policy, even the person who got injured during the training, they can continue beyond 2 years. That was not done. So this salient feature was not present in Biplab Burma.
Right.
So Biplab Burma, my lord, very well knows that it is not a statute. Judgments are not statute that they apply in every case. No. Biplab Burma had a different set of facts. And here, it is his case, my lord, you will see in the petition that he has written that I was sponsored for second time training in anticipation that relaxation will come.
No, but your order also states that. One of the orders.
Yes, the final order that with the high pending with the headquarter. Headquarter means ultimately the Home Ministry. So that was not given, so he was ultimately dismissed on the ground of not completing training within 2 years. So 27 doesn't apply. 27, if 27 would have applied, why not, then the medical board have to be constituted.
Anything else?
Nothing.
Reserved. Next.
With the legal.
Mr. Mishra, your apprehension is not correct.
That was not, I stand.
Yes.
But needs that.
I don't knew the reason why I was apprehended.
Sorry.
You are actually doing that document of giving the option to the petition. The second clause of petition.
I don't.
Whether he was given an option to resign or.
He was never given the option. I can tell you.
That would have been referred to in the order.
I can tell you, you look for any document, you will never find it.
Let me find it out.
I'm okay.
Next.
Madam,
Yes.
my lord, will kindly see the order dated 2nd of December.
My lord, I'm filing my affidavit.
File your exception. You file your exception. So you don't want to file.
Yes, but I have to file.
It's up to you. You don't want to file. What can I? Anyway, yes, filed it.
Yes, sir.
Learned Counsel for the respondent state has filed its affidavit in opposition.
Madam, I have filed my affidavit in reply.
Petitioner seeks how much time?
2 weeks. madam.
2 weeks time to file his reply to the same. Let this.
Next week also similar. If I think if it's ready.
No, in that matter, I'm not there.
Before the next available circuit.
In next matter.
6 and is granted 2 weeks time to file his reply to the affidavit. Next. 34. Mr. Barman, are you there?
We are filing it.
Where is it? Yes. Mr. Barman, Mr. Rahman, 33, 33, 33, Mr. Rahman, Mr. Barman, in item 34. Same order. Only the council has changed.
He's a cleaner, my lord.
Sir, you tell me what do I do with the urgency?
No, I'm just for the.
If you don't want to file your reply, I'll hear it this week. I'll decide it next week.
No, I'm not on.
Then what can I?
Saying, my lord, while kindly fix the parental date. Because.
That I
No,
can.
you have to file first.
I'll file it with.
You file it. I can file it within 2 weeks. Pass over, just one pass.
Password address, number 2.
I'm going to state.
Lordship, Tuesday, Lordship.
Dismissal matter, you are just pushing it and pushing it. Let me tell you, you're just pushing it and nothing else. Nothing in this matter.
Lordship, kindly taken.
Tuesday. All right. He has been waiting till 1:30. Take him out for lunch. All right. Tuesday. Tuesday.
Grateful.
দুটো না এটা